right, good morning. This is the 10 a.m. calendar. The first case on the calendar is Muhammad Mogis versus Marna Beauty Supply Inc. Muhammad Muntazer, Zaid Maslak Mushin, and John Doe are the parties here for that case.
I'm here for the respondent, Your Honor.
All right.
I'm here for one of the defendants, Judge. This is David Olson.
All right, the next case on the calendar is the Capital One versus Catrice Blades. Capital One versus Catrice.
Good morning, Your Honor. Attorney Tanisha Sims for the defendant. And Ms. Blades, I do believe is present. I thought I saw her.
Yes, I'm here.
All right, Ms. Blades, you're gonna have to turn your video on.
I'm sorry. I'll turn my video on. Later. Okay.
All right, there you
Was
are.
it on?
All right.
Oh, okay.
So for Capital One versus Catrice Blades, this is case 2025 CV 01290. All right, this is a motion to withdraw as counsel. So Ms. Sims, you were representing Ms. Blades in this case?
Yes, that is correct, Your Honor.
All right, so Ms. Blades, you understand that Ms. Sims is seeking to withdraw as your counsel, and you will be responsible for everything that happens in your case until either the case ends or until you get new counsel?
Yes, ma'am.
All right, and that means responding to any documents or motions that are sent by the other side, and you have to do it in a timely manner. And the court can't give you any advice about that. You would have to make sure that you respond as necessary. You understand?
Yes, ma'am.
All right. Is the address that Ms. Sims have for you, is that the one where things will be going to you from the other side until you get an attorney?
Say it again. I couldn't. The very first.
Does Ms. Sims have the correct address for you in her
yes, ma'am.
documents? Okay. All right. So at this time, do you have any objection to Ms. Sims coming off this case?
No, ma'am.
All right. All right. So Ms. Sims will go ahead and sign on your case and you coming off of the case of Capital One versus Blade.
Thank you, Your Honor.
All right. Thank you.
And I'm going to hang around for another matter for my colleagues, so I'll just stay on.
All right, Ms. Blades, you're free to go at this time.
Ms. Blades, before you leave, Judge, I just want to make a quick note that you'll want to confirm for yourself as well that the address that Attorney Sims has for you in her motion is also the address that the clerk's office has. You're responsible for that as well.
Okay.
All right, thanks, Ms. Powell.
Thank you.
All right, and you're free to go at this time, ma'am. Thank you.
Thank you. Bye-bye.
All right, the next case is Carmen Robinson versus Cerrito Western Wear. Anybody here on behalf of the plaintiff, Carmen Robinson?
Yes, Your Honor, I'm here on behalf of the plaintiff.
Your Honor, Edward Alo on behalf of the defendant.
All right, so Mr. Glass on behalf of plaintiff and Mr. Alon?
Alo, yes, Your Honor.
Oh, Alo. Y'all, these progressives are not video friendly. So if it looks like I'm looking at you crazy, it's because I'm trying to find the sweet spot. Yeah, Judge has a lot going on today, but we're going to get through it. All right. So I believe there was one more attorney withdrawal on this calendar. Let me go ahead and do that, and then I'll go back up to the top and we'll get started with the meteor motions.
Yeah, and that's going to be for Princeton Nelson, Your Honor, and I'm going to be stepping in place for my colleague, Mr. Michael Lee, Attorney Michael Lee.
Okay, and he's trying to come off of that case also?
Yes, ma'am.
Jasmine Short is here for plaintiff on that case, Your Honor.
I'm sorry, who's the plaintiff in that case?
That's LVMV funding as assignee, I believe, of Cross River Bank.
Position 8.
Oh. All right. So on the case of LVNV Funding LLC versus Princeton Nelson, is Mr. Nelson present? Mr. Nelson, unmute your device for me. You know how to do that?
Yes, yes, Your
All
Honor.
right. So, Mr. Nelson, the attorney for your case is wanting to be relieved from representing you in this case. And you understand that once they come off the case, that will mean that any responses that have to be made, any documents that have to be filed, anything that has to happen until this case is resolved or until you get a new attorney, they will not be responsible for that. It will be you. So any documents would come directly to you. You have to verify with the clerk's office that they have the correct address on file, and you would have to respond. Do you understand?
Yes, Your Honor.
All right. So at this time, on behalf of Michael Brandon Lee, Ms. Sims, you're representing that he's wanting to come off this case.
That is correct, Your Honor.
All right. Mr. Nelson, do you have any objections to Mr. Lee being relieved of this case?
No objection. No objection, Your Honor.
All right. All right. So in the matter of LVNV funding versus Princeton Nelson, for the attorney from LVNV funding, you're on notice now that Mr. Nelson will be handling all of the matters of this case until such time as another attorney makes entry in the case. So you'll be dealing directly with them.
Sounds good, Judge. And if Mr. Nelson would like to speak before you excuse us today, I'm more than welcome to go in a breakout room to try to see if we can resolve this.
Mr. Nelson, I can put you in a breakout room if you wish to do that.
Who am I speaking to?
This is Ms. Shorter. She's representing LVNV funding.
Yeah, I would love to speak because yeah, that would be great.
So what I'm going to do is I'll put you in a breakout room. When you are finished speaking with each other, then you will come out of the breakout room. So when you see the invitation to the breakout room pop up on your screen, that will also be when you're finished, you will activate your screen and you should see a button that says leave breakout room or return to main room. So you're not stuck in there. You just need to activate your screen. Okay.
Okay.
All right.
And Your Honor, that concludes my business. May I be excused by the court?
Yes, ma'am.
Attorney Sims. Thank you so much, Your Honor.
All
Have
right,
a great
Ms. Sims.
day.
You too. I'm going to go
Thank
ahead
you.
and activate the breakout rooms. Ms. Shorter and Mr. Nelson, I'll put you in the breakout rooms.
Okay.
Thank you, Your Honor.
All right. And I'm going to open those now. You should see the invitation pop up.
Okay.
All right. Thank you. All right. So back to the main calendar. On case number 1, this is a personal injury case. The parties are before the court. And it seems like there was a unfortunate gun discharge that happened with this case. All right, who's arguing the motion for summary judgment?
I'm arguing the motion. It's Matthew Dickinson.
Okay, Mr. Dickinson, just speak up just a little bit.
All right. Can you hear me?
Yeah, I hear you a little bit better now. Thank you.
Would you like me to proceed, Your Honor?
Yes.
All right. Thank you. All right. So first and foremost, Your Honor, we're asking that the court grant summary judgment to the defendants Mara Beauty Supply and Mohammed Muntaser on the claims asserted by plaintiff. We're not asking, just for clarity's sake, for summary judgment to the co-defendant, Mr. Moosen. Mara Beauty Supply and Mr. Muntaser are not liable to plaintiff under any theory outlined in the complaint. Plaintiff has asserted claims for negligence, vicarious liability against Muntaser and Mara Beauty Supply under premises liability. As the court is well aware, in Georgia, the essential elements for a cause of action of negligence are a legal duty, breach of the duty, an injury, and a causal connection between the breach and the injury. For vicarious liability, a servant must be acting in the furtherance of the master's business. They must be acting in the scope of the master's business. As established in the Brownlee case cited in our brief, if a tort is committed by an employee not by reason of the employment, but because of a matter disconnected therewith, an employer isn't liable. And summary judgment as established in that same case for the master is appropriate where the evidence shows that a servant was not engaged in the furtherance of the master's business, but was on a private enterprise of his own. Under the theory of premises liability, it imposes upon the proprietor a duty to exercise ordinary care in keeping the premises safe for invitees. Now, whether the proprietor had superior knowledge of the defect or dangerous condition requires that there be some knowledge on behalf of the owner, as we all understand in a premises liability. So just so I can give you a quick breakdown of the facts, Your Honor. On Friday, March 19th, 2021, plaintiff and Mr. Mushin, his manager, had just closed down Marlboro Beauty Supply for the night to go back to their homes. Plaintiff didn't want to pay for an Uber, so he asked Mr. Mushin, or Mr. Mushin offered to give him a ride home. After plaintiff got into Mr. Mushin's car, at some point in time, they were playing around with Mr. Mushin's pistol, and it went off, causing plaintiff injuries. As we all understand, the incident occurred entirely in Mr. Mushin's car with this gun, and this happened in the parking lot outside the business. Now, Mr. Muntaser, one of my clients, denied providing any pistol to Mr. Mushin. He denied that he was ever hired to perform any security. He denied that the shooting was performed in the scope of Mr. Mushin's employment, as of course, Mr. Mushin wasn't a rideshare, he wasn't a cab driver, and he has stated during his sworn deposition that he was doing this as a favor to plaintiff. Mr. Mushin also denied being told to carry a pistol as part of his employment, and denied that he was tasked with providing security on the premises. While the allegations are unclear as to what exactly plaintiff is claiming, I believe you can boil it down to simply vicarious liability and premises liability. Likewise, the claim for premises liability is unsubstantiated. Mr. Muntaser denied any prior issues in the parking lot of the business. No complaints were ever received against Mr. Mushin in his capacity as the manager of the business. No prior threats or anything along those lines that could be in front of a jury for them to even fairly consider this. And since there's a lack of criminal activity on the premises, there's no allegation that the premises was less safe or unsafe. More importantly, plaintiff has no experts which have been designated to speak as to what security would be needed or how existing measures on the premises were inadequate. Merely stating that security was inadequate or training for employees was inadequate doesn't actually address what the inadequacy is concerning what needed to be done to remediate these problems. Plaintiff has not presented any evidence to the jury to determine the premises were less safe nor any measures that could be taken. And as we understand under Georgia law, private businesses cannot restrict the ownership of firearms by employees except in specific circumstances. As outlined in OCGA 16-11-135E, no employer, property owner, or property owner's agent shall be liable in any criminal or civil action for damages resulting from or arising out of an occurrence involving the transportation, storage, possession, or use of a firearm, including but not limited to the theft of a firearm from an employee's automobile pursuant to this code section, unless such employer commits a criminal act involving the use of the firearm or unless the employee or the employer knew that the person using the firearm could commit such a criminal act on the employer's premises.
So I have a couple of questions.
Certainly, Your Honor.
The manager, Mr. Mushin, was required to close the business.
Yes, we understand from the deposition testimony of plaintiff that he actually physically put the key in the lock and closed the door, but he was outside watching this occur in his car.
Who was watching it occur?
Mr. Mushin. So Mushin is the manager. I could just refer to him as manager to keep it easier.
So the manager is required to close the business. He has an employee with him who's working to close until close. That was his shift.
Yes.
Okay, he wasn't an employee, person who the manager said, well, if you close, I'll give you a ride. He was required to close. So the two of them were working together.
Yes.
And as part of the closing of the business, would Mr. Mushin have had to deposit money or take money away from the business?
No, Your Honor. I asked that question during his deposition, and he confirmed he wasn't carrying money for the business at the time. He did occasionally carry money to the bank for deposits, but that was not the purpose of this trip.
Okay. did he have the firearm in furtherance of the protection of himself or the assets when he did take money to the bank?
So
Is that in the record?
no, it's not. The key issue here, Your Honor, which is kind of like a splitting of the hairs, is that Mr. Moosen, the manager, has stated that he purchased a pistol for the purpose of protecting himself. And of course, he used it in connection with the business whenever he was driving the money because he felt like it kept him safer. While the owner of the business, Mr. Muntaser, maintains that he had knowledge that the manager owned a pistol, he was never instructed nor directed to use that pistol in connection with any official scope of business of Marwa Beauty Supply, which is key because in this case, plaintiff has alleged that he's operating in a security role. It's kind of like, I believe I established it in one of the cases that I mentioned in my brief, which in that case, one of the employees put a pistol in his car, and as he kept it for his own personal safety because he would have to go to people's houses and do house visits, and he felt like that would maintain his security. It's not a part of his official scope of business, nor his duties as a part of working for the company.
All right, I'm sorry, continue.
Okay. So back to the vicarious liability. Plaintiff needs to present evidence to show how the incident in chief was in furtherance of the business of Marwa Beauty Supply. The Georgia Supreme Court has rejected a but-for argument that an employer is liable for negligent hiring or retention of the tortfeasor solely because his or her employment provided the tortfeasor with access or opportunity to injure the plaintiff. Under the concept of premises liability, it imposes a proprietor duty to exercise ordinary care and keep the premises or approaches safe. We don't know what the condition of the hazard or what hazardous condition plaintiff complaining about, especially since the person who owned a firearm, the manager, Mr. Moosen, lawfully owned a gun. He had no criminal history, no prior incidents or any sort of complaints, which would put Marwa Beauty or Mr. Muntaser on any notice that he was a problem or could pose a threat or a problem to invitees, licensees, trespassers, or more importantly, employees. And since there's no experts to speak as to this hazard, there's a lack of any sort of evidence for the jury to consider as to this point. There's no reason to assume from the evidence we've seen that premises liability would be at issue in this case, and it should fail as a matter of law. Plaintiff needs to, again, point to specific evidence as why the premises were less safe and what hazards existed. And he would also have to prove that Marwa Beauty or even Mr. Muntaser had actual or implied knowledge of the hazardous condition of Marwa Beauty Supply.
All right. Did you have anything else before Mr. Weeks responds?
Yes, briefly, Your Honor. Plaintiff claimed in his complaint that the property was not maintained, though he doesn't mention the hazard. He says that plaintiff was shot by Mr. Moosen, who had no criminal history, no prior incidents, and even claims to have a concealed weapons permit from Florida. With the facts that we have, there's no reason to have a jury be able to determine that either Mr. Muntaser in his personal capacity or the business itself would have any liability for either vicarious liability or under premises liability. Importantly so, when it comes to vicarious liability, this was the defendant, Mr. Moosen, offering to take plaintiff home for the night. It wasn't in any way connection with any business. Mr. Muntaser expressly denied that during his sworn deposition, as it wasn't a part of the scope of the business to give employees rides home for the night. And since this entirely took place, the shooting entirely took place in Mr. Moosen's car, we can't control the activities in a private employee's vehicle. We can only handle how we discipline them if we find out about any malfeasance. Again, Your Honor, we're not asking for summary judgment on behalf of Mr. Moosen, but only as to Marwa Beauty Supply and Mr. Muntaser in his individual capacity. Thank you again for your time, Your Honor. I appreciate it.
I have one more question. So my understanding from the record is that there was a possibility that at one point someone claimed that the gun had been given to the manager, Mr. Moosen, by the owner.
Yes, Your Honor. I believe plaintiff is making that allegation. And even if the court were to assume under the summary judgment standard that Mr. Muntaser gave him a pistol and said, hey, use this whenever you're driving to go deliver money for the business to the bank. No criminal history, no prior incidents, no prior complaints, nothing by which they could say that that act in and of itself was negligent.
All right, thank you. All right,
Thank you.
Mr. Weeks.
Good morning, Your Honor.
Good morning.
If I may, and I don't know if the court can see my chart, and if
I
not,
can. It says Iraq.
yes, Your Honor. I just always like to start legal arguments with the old bar exam approach. Okay, so the issue is whether Mr. Mushin was acting in the furtherance of the employer's business and in the scope of the employer's business. Because we know if he was, that the employer is liable. We also know that the rule is that an attorney can make admissions on behalf of his client. And what do we know based upon those rules and applying the evidence? We know that Mr. Mushin was using the gun to protect himself, and we also, and the money from the company. We also know that his lawyer in a previous hearing said that the employer provided the gun. And if I may, let me just revisit those. Prior to the shooting, Mushin told his supervisor at Marwa that he had a gun to secure himself and for the job, to protect the money for the company, transporting it to the bank. Before Judge Mack in the criminal matter, the Mushin gave the following testimony. Question: who did you work for at the time of the shooting? At the time the shooting took place? Beauty Exchange. Who's the owner? Mohammed Muntazer. All right, to carry that gun was part of your job at the beauty supply place? Yes.
Okay.
And the owner supplied you with a gun? Yes. Part of your job was to take Mr. Mogee's home that day.
Okay.
So part of your
bye-bye.
I'm sorry, someone's video is on and I'm hearing you. Please, everyone mute if you're not speaking at this time, okay? Go ahead, Mr. Weeks, I apologize.
That's all right, Your Honor. I was getting a little lost there myself. Mr. Mushin was asked, part of your job was to take Mr. Mogee's home that day. Part of your job as a security man, you had the gun. Another part of your job was to take Mr. Mogee's home that day. Is that right? I was supposed to take him home? Yes. And this shooting happened while you were in the parking lot of the beauty supply place. Is that right? Yes. In keeping the gun, taking him home, all that was done at the direction of your employer. Your boss is the one that told you to do all that. Answer: it was protection for me because, you know, I always move money. Okay, for the business? For the business, yes. All right. Part of your job, right? Yes. That is what Mushin told Judge Mack. His very competent and qualified attorney, who honestly I think I've known for around 40 years, did a great job. But he said to Judge Mack in that hearing, there's a lawsuit waiting to happen against the owner of this business who sounds like he authorized my client, that'd be Mushin, providing him with a weapon to provide security during the course and scope of his employment. So that was what was said under oath in a previous hearing on this very same matter. We also know that an employee, that is Mushin, is still in the course of his employment while he's in the parking lot. That's the Tate versus Bruno case. The shooting occurred where? In the employee's parking lot. We also know that the course of employment continues during the assault if any part of the initial matter was related to the business. What does that apply to the facts? He was taking the employee home as part of his job, and that was in the advanced disposal case that decided that.
All right, so Mr. Weeks, hate to interrupt, but was it the normal course of, let me just say it because I don't want to use a term of art, was it a routine practice for Mr. Mushin to take the plaintiff home after they closed?
I do not believe so. I think this was an aberration. And in fact, I think the evidence was pretty clear that the employee said, no, and Mr. Mushin insisted that he get in the car. And the previous argument, they were playing with a gun. The only person that the evidence said was playing with a gun was Mushin. Now, so we come to this issue in this case, and there's two witnesses that contradict each other. You've got defendant Mushin in a court hearing, and you've got defendant Mushin in a deposition, and they diametrically oppose each other. Before Judge Mackey says, yeah, the employer gave me the gun, told me to use it, and I'm just protecting the businesses and their money. And then later on in his deposition, he said, oh, no, that was not true. I didn't mean to say all that. And also, of course, his previous counsel argued that very same theory. So we come to the prophecy issue, the prophecy versus Charles Rossignol case, and a party who makes contradictory statements is held against that witness. And of course, under Rule 620, the jury decides credibility, and under 621, they can decide that contradicts his previous statement. Or they can say, a jury could in this case say, yeah, we think he lied to Judge Mack. Maybe none of that's true. The jury could conclude that, I suppose. So, was he acting in furtherance of the business? Clearly so, still in the parking lot. So
point me directly to the part where he was acting in furtherance of the business. So once he wasn't taking money to be deposited that evening, once the doors are closed and locked, one would presume that as soon as you walk away, unless you're in a company car and you have some business that you have to do with the job after that, as soon as the door is locked and you're in your car in the parking lot, then the scope of your work ends at that point. So what is it that connects Mr. Mushin being in his car in the parking lot of the business with the scope of the business as a beauty supply store?
He is taking an employee home, and he said that he was directed to do that, or that was what he was supposed to do from his employer. That's what he said to Judge Mack. Also, respectfully, under the Tate versus Bruno case, a person continues in their employment until they exit the premises. So Mr. Mushin was still in his employment until he had a reasonable time to exit the premises. They were still in the parking lot, still in the car.
Okay. All right, continue.
The second issue is the employer liable for punitive damages, and of course.
Well, I think we're first at whether he's liable for damages, period. Now we're at punitives.
Well, that's just part of their brief. I mean, I think in this case, frankly, he's taking the employee home. He has the gun he uses as part of his security job. I think Mr. Mushin said he was putting it away. There's some testimony he was playing with it, putting it away, one or the other.
Okay, so to put it away presumes that it was taken out for a reason. Is there any testimony as to why the gun was taken from whatever safeguard it was in the presence of the plaintiff?
No, he just said he's playing with it or putting it away. So other than putting it away or playing with it, there's no other evidence of that.
Okay, and also, was the gun on Mr. Mushin's person as he went about his work at the store, or was the gun stored in his vehicle? Because Georgia,
there was contradictory testimonies. I recall Mr. Mushin said he kept it in his car. I think the plaintiff said he sometimes carried it in the store, but that was not. Frankly, it wasn't briefed, and I didn't think about that as being an issue. So it is our belief that given that he was acting as security for the store, for the money, that's why he had the gun. The gun was given to him by the owner of the business. The owner of the business, Mr. Montaser, said, I don't know if you had any training or knew how to use it or not. I didn't have any company policies about carrying guns on the property.
Last question. Was there actually a person hired to serve in the role for security for the business?
There was not, Your Honor.
Okay. All right. Anything else, Mr. Weeks?
That is all I have, Your Honor. Thank you.
All right, Mr. Dickinson, anything else?
Yes, just briefly to point out some of the things I think plaintiff just mentioned. So he mentioned that the attorney admissions are on behalf of the client. I want to just remind the court that during the restitution hearing, the criminal case, we weren't a party. So none of those admissions as to what he's saying his scope of employment are admissible against us. Mr. Moontaser, the owner of the business and the manager of the business, he kind of knows what those situations are and has been fully deposed on those concepts as to authoritatively stating Mr. Mushin did not work as security. He did know he owned a firearm, like I said previously. And in that restitution transcript that plaintiff's counsel just mentioned to you, he stated specifically it was protection for me. That's because he felt he needed to use a firearm to protect himself while he was doing this. It wasn't a direction or advice or even a requirement of the job that he carry a pistol. You can do this in the state of Georgia because we all have a Second Amendment right unless it's abrogated by obviously felonies or criminal history,
yeah.
which he doesn't have. He had a CWP in Florida. So there's no reason for us to assume that any of those admissions would operate against Mara Beauty or Mr. Moontaser. He said also he cited the Tate versus Bruno case. That's a workers' compensation case. There was no workers' compensation case or claim filed by plaintiff to our knowledge. And of course, any contradictory statements that Mr. Moosin stated would not be interpreted against the company. Simply because I say in a deposition or on a restitution hearing that I'm the president of Iran doesn't make it an actual relationship. There has to be something, some acknowledgement or verification in this case by the employer of those roles and of those duties. And those don't exist in the present case, Your Honor, in any way, shape, form, or fashion. The only way plaintiff has been able to get this far is by claiming that those contradictory statements in his sworn and Moosin's sworn deposition and the restitution hearing should create a genuine issue whenever they don't not only not create a genuine issue, but there's still no existence of habitual recklessness. There's no prior complaints. There's no prior criminal incidents. There's nothing to even put us on notice that this would even be a problem, especially when they're in a private vehicle by an employee after hours while he was offering. And of course, Mr. Mogies, the plaintiff, accepted a voluntary ride home. That's not in the scope of furtherance of our business, Your Honor. And thank you again for your time today. I appreciate it.
No problem. All right, so we will get you all in order as quickly as we can. Thank you all.
Thank you, Your Honor. May we be excused?
Good to see you. Good to see you,
Thank
Mr.
you.
Weeks.
Thank you, Judge.
Good to see you as well.
Your Honor.
Yes.
On position 8, Mr. Nelson and I were able to reach an agreement. I have emailed him the consent judgment for him to review and send back. And as soon as I have the signed consent from him, I will get it filed with the court.
All right. So I'm glad you all were able to reach an agreement. It's always better if y'all reach an agreement than if I impose one. So Mr. Nelson, please keep in touch with the individuals that you are to, send the money to. If there is any problem ever, just reach out to them ahead of time and maybe they'll continue to work with you under the terms and conditions of the agreement. And as soon as I get it, both of you will get copies of it. Okay.
Thank you.
All right. Thank you both. You're free to go at this time.
Thank you so much, Judge.
Okay. All right. So the next case is the Capital. Oh, no, I did that one. Carmen Robinson versus Cerrito Western Wear. Are we ready? Case 2024 CV 04572.
Yes, Your Honor. Your Honor, Edward Alo on behalf of the defendant. This was the defendant's motion for summary judgment. I did prepare a PowerPoint presentation. If I could have court's permission to share that.
You may.
As I mentioned, Your Honor, this is the defendant's motion for summary judgment. I know the court just heard a summary judgment motion, but just to refresh the court's recollection, summary judgment is appropriate whenever there's no genuine issue of material fact that shows the the move-in is entitled to judgment as a matter of law. This is a premises liability matter in which the plaintiff is claiming as an invitee she suffered injuries on the property. The general rule whenever it comes to these premises liability matters is that a plaintiff is not entitled to recovery as an invitee if the undisputed evidence shows the plaintiff's knowledge of the alleged hazard was at least equal to that of the property owner or possessor. In this particular case, the defendant offered 3 specific issues to show why we are entitled to summary judgment. The first being that the evidence in discovery at this point, there's no evidence that actually shows that this subject stool, which the plaintiff claims that she tripped on and fell, there's no evidence that shows that that subject stool actually caused the plaintiff's fall. The next basis would be that the plaintiff had constructive knowledge of the stool because the stool was a static condition. And lastly, the knowledge of the stool would be imputed on the plaintiff, therefore giving her at least equal knowledge of the stool under the prior traversal doctrine. So just going along the lines, the plaintiff's claims are brought under OCGA 5131, which provides for liability on an owner possessor of property for injuries caused to an invitee for failure to exercise ordinary care in keeping the premises safe. Going to this specific matter, Your Honor, the plaintiff's own testimony said that she walked into the store on the day of this incident. She had walked around the store for, I believe, about 30 minutes looking at the products and the inventory before completing her transaction. Assuming she would have been facing the counter, turned to her right to then walk towards the entrance/exit, and after taking a couple of steps, fell to the ground. She testified that she never saw the stool prior to the fall at any point. She testified that she believed the front of her right foot struck the stool and caused her to fall, but she has no memory of actually making contact with the stool with her right foot. She, again, never saw the stool until she was on the ground, and she further stated in her deposition that her only basis to believe that the stool caused her to fall was because the stool was in the area. It is clear from Ms. Robison's deposition that she does not know what actually caused her to fall, and rather her testimony regarding the stool causing her to trip and fall is just speculation. And Brown versus Emerson, Georgia Court of Appeals, which is 220 GA app at 318 in 1996, says that speculation is not enough. Speculation is not enough to survive a summary judgment motion. And I believe a photo of the stool was included as part of the summary judgment motion. If it wasn't specifically, it was an exhibit to Ms. Robison's deposition, and this is actually exhibit 2 to Ms. Robison's deposition. So,
was there video?
There was not, Your Honor.
No store. You got a retail business that doesn't have video?
There was video.
There was video, but it wasn't preserved in enough time. I believe it was written over before they became aware of the claim. So as I mentioned before, premises liability is rooted in this idea of the possessor, owner, superior knowledge of a condition. But if nothing prevents the invitee from seeing the hazard, then there is no liability on the owner or possessor because it's presumed that the invitee had at least equal knowledge of the condition as the owner.
So in a retail store, the basic premise is that you're going to keep the items for sale at eye level. The most attractive items are going to be at eye level. so that the person who's perusing the merchandise is going to essentially be looking at those things that are for sale, maybe a little bit lower table where I can look down and reach down and pick up an item. But is this a store where she would have been compelled by the placement of the items to look on the floor or at floor level? Because when you said stool, when I read the briefs, I'm thinking like a stool that somebody would sit at a counter. But in this case, this is one of those little step stools that you put to assist you in getting to a higher shelf or something. So is there anything that would have compelled her, since the basis of your motion is that she would have had equal or superior knowledge, is there anything that would have compelled her to draw her eyes down to that level as opposed to looking at the items for sale that were presumably higher than the stool?
Sure. So I think what the court is getting at is the distraction doctrine exception to the static condition doctrine. So let me shift to that.
Yeah, I took a lot of words to say that, but yeah.
So essentially, yes, there is an exclusion to the static condition doctrine under the distraction doctrine. In essence, the distraction doctrine is whenever the possessor of property creates a distraction which diverts the customer's attention, allows that hazard, and in this case would allow the stool to be the proximate cause of the injury, setting aside the static condition doctrine. However, if we go to Sears, Roebuck and Company versus Chandler, the Court of Appeals, I believe it's this one, has said that, you know, this attention-seeking merchandising and signage is enough to be considered a distraction. However, there still needs to be some evidence from the plaintiff that says that they did not see this stool because of, you know, they were looking at the merchandise, they were looking around. There needs to be that type of evidence there. But in this case, Your Honor, there isn't. Ms. Robeson was actually asked, you know, about that, and there is arguments by plaintiff's counsel that, you know, her view was obstructed because of a shopping bag, but that is only argument. We have to actually go to Ms. Robeson's testimony, and she had been asked multiple times and said multiple times in the deposition, you know, she just did not see the stool because she was not looking for it. She did not say or otherwise testify that she was distracted. She did not say that the view was obstructed. She doesn't recall really what she was doing. She was saying, you know, she could have been doing this, that, or another thing. She doesn't really recall what she was doing, but she was very clear multiple times in her deposition that she did not see it because she was not looking for it.
Okay, let me ask this. What you keep saying that the stool was a static, it was static, but it's a movable stool, and the purpose of the stool is to move it from place to place in order to access the higher, access things on a higher vantage point. So was that stool there all the time, right in front of the retail counter, or did it move from place to place?
So first, I just want to break apart two things in terms of while the plaintiff was at the store, there's no evidence that the stool had been moved from the location it was at the time of the plaintiff's fall. There's no evidence in discovery, but just generally speaking, yes, there is testimony that the stool would be moved to wherever it was necessary. I believe one of the employees at the location was vertically challenged and used the stool to be able to reach up higher and would need to get up and move that stool as necessary. But that being said, this movable object idea is something that the plaintiff did bring up in her brief. And if we go to, there are multiple cases that have said that just because a condition can be moved does not prevent it from being a static condition. The definition of a static condition, and I can go back to that slide, is a condition that does not change and is not inherently dangerous. It is an open and obvious condition if nothing prevents that person from seeing it. Going to the cases where courts actually considered movable conditions in, I'm going to butcher this, Gallacher versus Dollar Tree Stores, which is a Northern District of Georgia case from 2025, and that's 2025 U.S. District, Lexus 123101. They specifically found that an A-frame sign, like a wet floor A-frame sign, constituted a static condition. In Rents versus Prince of Albany, Inc., it was at a car dealership where they found that a cornhole set, which, cornhole set is a movable condition, and that constituted a static condition. And then finally in Barwick versus Dillard House, Inc., and that's 2023 U.S. District, Lexus 241312, Northern District of Georgia, 2023, specifically held that a movable object can fall into the definition of a static condition, as long as it is a condition that does not is not obstructed from the plaintiff's view. And again, Your Honor, in this matter, she's not claiming that it was hidden. It wasn't like under a pile of clothes. It wasn't under a pile of anything.
So your argument is entirely based upon the fact that while the plaintiff alleges that she fell due to something in the store, there's no evidence from her testimony of what either it was actually that she fell upon or fell because of, like, the stool was there, she may have, but there's no evidence that she may actually made contact with it, or there's no evidence also that her view was obstructed by anything that would have been present, either clothes, or she hasn't stated those things such that there's evidence that a jury could consider.
Absolutely, Your Honor, yes. And just going back to, the static condition doctrine, the courts have been very consistent. The Court of Appeals, as well as the Georgia Supreme Court, has said that the invitee's failure to look, or even just the invitee's failure to see a static condition, does not relieve the invitee of responsibility for not seeing the static condition. Just because you didn't see it doesn't mean there is a breach of a legal duty.
Okay.
I am arguing those two alternatives. And then the last issue, I already talked about the visibility exclusion. There's nothing that she said that the lighting wasn't sufficient, nothing that she said that obstructed her view. She just didn't see it.
All right. And as a former shopper, less so now, but there's a tendency to like pile a bunch of things in your hands, especially if you're in a higher end store that doesn't have a buggy, to take them to the checkout.
So, Your Honor, she had actually the plaintiff had actually completed her purchase and was leaving at the time of this fall. And I believe she did say she had a bag in her hand. She didn't remember how she was holding it. She said it may have been in her right hand, but she just doesn't recall.
And she didn't hit the stool on the way to checkout.
Correct.
Okay. All right.
And she did say, oh, go ahead, Your Honor.
Well, because part of the equal and superior knowledge would have been had she goes up to the checkout to check out and the stool was there, then she moves away from the checkout and the stool was there, but on the moving away, she hit it. So the argument, I guess, is, did she appreciate that the stool was there as she approached the checkout and was able to see it at that point?
So, Your Honor, I believe what the court may be going to is the prior traversal doctrine. So let me get to that. So the prior traversal doctrine is judicially stated that when a person has successfully negotiated an alleged dangerous condition on a single previous occasion, that person is presumed to have knowledge of the condition and cannot recover. It's not necessary for the person to have actual knowledge of the alleged condition, but rather to have been in that area and successfully, I guess, avoided the condition or avoided the harm that was subsequently incurred. So all that's needed is that one single action. It doesn't have to be multiple times. It just is a single prior traversal. So going to the plaintiff's testimony herself, as I mentioned before, she had spent about 30 minutes in the store before completing her transaction and the fall occurred. She testified multiple times that she never saw this stool prior to the incident. And in those 30 minutes, though, prior to her fall, she conceded that she walked around the store. She walked around looking at all the merchandise. And she actually admitted, and this is page 88 lines 5 through 13, as well as line 25, and page 89 lines 1 and 2, where she conceded that she actually walked in the area where she fell, in the area where the stool would have been prior to her fall. So this, Your Honor, establishes at least one single prior traversal of the area without issue to establish, that the knowledge of the stool should have been imputed on the plaintiff, establishing, no liability per the prior traversal doctrine. It's our position, Your Honor, whenever you look at the stool on the flooring, it's an open and obvious condition. It's just, whether or not the plaintiff, she didn't see it. There's no hints about she did not see it. She's testified to that. And it's our position that, her failure to see it does not establish a breach of duty on behalf of the defendants.
And the stool, would we have considered that it was properly placed there, or in a place where it would not cause a hazard? Or doesn't that matter?
I don't believe that matters, Your Honor. As long as it, is an open and obvious condition, as long as, nothing is obstructing the invitee's view of the stool, this plaintiff isn't distracted or can provide the testimony that or doesn't provide testimony that she isn't distracted by the merchandise or things like that, then it falls under the static condition doctrine.
Okay, and last question, from the picture, what I ascertain is that where the rug is would have been where the checkout part was?
Yes, Your Honor. And my apologies, this photo might be a little bit misleading. We don't actually, this photograph was taken like as an exemplar, because we don't actually know.
Yeah, I didn't think that it was the actual taken at the time. I'm just trying to get the setup so that somewhere in front of this counter was the stool.
So it would have been, according to the plaintiff's testimony, where she believes she fell. I believe she checked out here at this counter. After she checked out at the counter, she would have taken, I want to say it was like 3 or 4 steps. This is in her deposition testimony. So if Your Honor wants to go back to her deposition testimony and review it, she took 3 or 4 steps, which would have been to the right of this photograph towards the exit. And that's when the fall occurred. And it wouldn't have happened. It did not happen like right up against the counter, but rather it would have been closer in area and in space to the person that was taking this photograph.
Okay. All right. Mr. Glass?
Yes, ma'am. There's a lot to unpack. Literally what Mr. Allard just said, his very last statement, that's just speculation. She doesn't recall where the stool was. And I say she, I mean Miss Serrano and the plaintiff. Okay, so I'm going to go all the way back to the very beginning, because the first argument that the defense brings up is that she can't even prove that it's the stool that tripped her. The employee admits in her testimony, was it, and I'll give you, I hate to just recite the brief, but was it then that you could see she tripped over the step stool? The employee's answer was yes. How did you know it's the stool that tripped her? Answer, it was the only thing that was like on the floor. Then the plaintiff testifies, I know, I was just walking and I tripped over a stool. That is on its face, her saying that she tripped over the stool. She goes on and says, I just know that I hit it and I fell. Again, direct testimony that she hit a stool and fell. So I just want to put that to bed. In her, and you can go back and review her deposition, but plaintiff's counsel asked her many, many different questions, and at times she just didn't answer exactly like I hit it and I fell. He circled around it many times. So if you want to go back and review it, there's plenty of testimony that says that she hit it, and that's what tripped her. I also want to go back to Ms. Serrano's testimony, which is extremely important because it speaks to this entire argument about whether it's a static condition. I asked her point blank, do you know how the stool was placed in front of the counter? She says, no, I don't remember who put it there. There were 3 people working there that day, and I don't know who put it there. So to speculate and say it was sitting there for 30 minutes, he can make that argument to a jury, but he can't argue it to the judge because that's not a fact. That's a disputed fact. It could have been there 5 seconds before she turned to walk out of the store. We just don't know. The one employee that could have testified to it says, I don't know how it got there. Presumably when it was there, she has no idea. All she knows is they moved around the store to use it, which you correctly asked in your question to defense counsel. I highly dispute whether this is a static condition. A jury should decide that, first of all. But it's 10 inches off the ground, and it's used to help people reach things that are higher up off the floor. And she testified all of them are short. So presumably this stool got moved all over the place. And most importantly is we have no idea how long the stool was there. The jury can decide that, whether or not they think that stool was there for 5 seconds or if it was there for 30 minutes. The bag that's been brought up that was handed to her, it was at the deposition. I don't have a photograph. I don't have the same, but it was used at the deposition. We did measure it. It's 20 inches by 23 inches wide and tall. That's almost 2 feet by 2 feet. And it's 17 inches wide once you put items in it because they sell a lot of cowboy hats. So because they sell a lot of hats, these bags are very big. And she acknowledged that was one of their bags that we brought to the deposition. So I asked her, for the sake of, I hope it didn't sound really dumb to Miss Serrano, but how does a sale take place? You hand her the bag over the counter, correct? And she says, yes. And I said, well, did she drag it along the counter as she was looking, to see this stool? And it was such a weird question for her. She's like, I don't remember her dragging the bag. So she would have turned with the bag like any other customer, and that's going to block your view of this little 10-inch stool on the floor. Lastly, the defense makes an argument about whether or not it's open and obvious. Again, this is a question for a jury, not for a judge. We're talking about a stool that in the photo, it looks white, but there's gray dots on top of the stool. You're talking about a gray floor. No one can really pinpoint exactly whether it was up next to the counter. Presumably it was because she testified we used it to reach up and touch merchandise. So it wasn't 2 feet off. And defense counsel's correct. Many, many times he asked and tried to say that maybe she traversed that area or she saw the stool. At no point does she say she ever saw this step stool. So for all we know, one of the employees was helping someone else in the store while she's shopping and popped that little stool out 10 seconds, or even while she's checking out and buying her stuff. There's just no testimony to it. So the very beginning, counsel said it has to be undisputed evidence for the court to find in favor of the defendant. And we have a lot of disputed evidence. We have disputed testimony for the jury to decide. I did spend some time in my brief talking about whether or not this is a static condition. Defense just brought 3 cases to the court that I've never seen before and presented them to you. It was not briefed about what is a static condition. So I would argue an A-frame, which, by the way, I have no chance to review those cases, but I would assume an A-frame is a lot taller than 10 inches off the ground. Cornhole boards that I've seen are huge compared to a tiny little step stool. So I don't know if in those cases that was considered, but the cases that I found were mostly about objects that are not movable per se. They're placed there, and clearly this was moved all over the place. And they even kept it in 2 different places in the store. They kept it in the storeroom and they kept it right behind the counter. Your Honor, I want to go back because I did obviously take notes leading into this hearing. I wanted to highlight to the court there is a Walmart case from 2006 where the court found it was a factual issue for a jury to decide when a fan was placed on a high shelf. The jury needs to decide if the business knew or should have known it was a dangerous condition. In our case, I asked the employee, do you believe that a step stool is a dangerous or a trip hazard? And she answers yes in her testimony. So the defendant admits that it's a dangerous condition to have a little step stool around the store. And that, in the Walmart case, that was for the jury to decide. And in our case, I don't think the jury's going to have a hard time figuring out that this was a dangerous condition. It also highlights the Perkins case, which is from 2010. I really like the Perkins case because it's a little more on point for us, and it says that an invitee is entitled to assume that the owner-occupier has exercised reasonable care to make the premises safe for the invitee. And here's the key part, and continues to exercise such care while the invitee remains on the premises. So this would be something I would argue to a jury, that they were not continually exercising care by moving this stool around, presumably while she was shopping. That's a question for the jury. And so for today's purposes, plaintiff would put that there are multiple questions and that the defendant's arguments fail just on the face because there is disputed evidence, given the fact that it's not a static condition, one, and two, they have no idea when the stool was put there or how long it was sitting there. And all of that is a big predication for the defense to win their argument, is that she priorly traversed this stool. Well, there's no evidence of that. She didn't see it. Obviously, if she'd seen it, she wouldn't have fallen over it. And then their own employee admits, yes, that's a tripping hazard. So we thank the court for your time. If you have any questions, happy to answer them.
All right. Mr. All, anything else?
Yes, Your Honor, just briefly. First, Your Honor, the duration of time that the condition existed, it has no bearing on the static condition doctrine. There is absolutely nothing in the static condition doctrine. Whenever you go to the case law that enumerates it, and it's cited in the defendant's brief as well, it just requires.
Do you mean that there's no specific amount of time that it is required for it to be considered a static condition? Because the nuance for me is that if the plaintiff walked away to the other side of the store and the stool was moved to go get something, and then the employee brings it back and puts it there, it doesn't have to be there for 10 minutes to be considered static. But if the employee, when she turns her back, that stool comes in and is placed in front of the cabinet, it's not moving at the time that she would have come back to the counter. But the fact is that I'm not talking about a particular time limit. If she walks away from the counter, stool's not there, she turns her back, the stool is placed there, she comes back to the counter, it's not particularly static because it moved between the time she moved away from to the counter and away from the counter.
So, Your Honor, a static condition, just by its definition under case law, is just an open and obvious condition that is static with nothing preventing a person from seeing it, such that a landowner may safely assume his invitees will see it and recognize the risk.
I get that, but safely assuming that something, and this is why I asked initially about where things are placed, because in a retail store, like I said, your upper body, I used to work retail a long time ago, and your upper body, like they're going to place things from probably waist up that they really, really want you to look at. Things below that are probably things that they don't care a whole lot about. But waist up is where they really want your attention focused, because that's where they're going to put the high-end products. That's where they're going to put the things that are name brands. That's where they're going to put the things that they really, really want to sell. And so they're going to draw your attention up to sell the more expensive and more premium products, waist up. If the person is walking around, they're not going to be walking around in a store where the whole point is to have your eyes drawn to the merchandise with their head down for a stool that's only 10 inches off the ground. And that's why I asked for clarification, because when you said a stool, we could talk about a stool that sits at the counter for you to sit at the counter and fill out paperwork, or, complete a transaction, or something that can be moved around and assist someone. So I don't know that I believe that the argument that it is a static condition just because it was sitting there and it's in the open, a lot of things can be floor, like close to the floor, and people will be looking ahead and not see them. And so that's the difference for me, is that this is not a place where they were, showing vacuum cleaners or selling Roombas where they're roaming around the floor. And she should have seen that there was a Roomba coming because she's in a Roomba sales floor. This is a place where naturally your eye is going to be drawn from waist up because you're buying products that they have displayed, and you can see all the hats on the counter. If I'm looking for a hat, and my eye's going to go straight to the hat, not to the stool in front of the counter that's way below the hats. And so that's what I'm just saying. I get that there's no particular time where a condition becomes static if it is open and obvious. But my issue, I think, with the argument is whether this was open and obvious such that she should have visually appreciated it under the circumstances.
So, Your Honor, to your point, there is testimony in her deposition where she was asked, where were you looking in the moments before your fall? I mean, that's a pretty important question for premises liability. And she just says, I was amazed at the store. I was looking around and I was talking to the cashier, I'll be back.
She does not recall, actually. She does not recall.
I'm reading from page 53, line 14. You asked the question, where were you looking in the moments before your fall? I was amazed at the store. I was looking around. I was talking to the cashier, I'll be back. I can remember like some stuff, but I'll be back, I love the store. I know I was talking and I was walking. So the employee's behind the counter. Obviously, she's not talking backwards over her shoulder. She's presumably looking at the cashier as she's starting to turn to walk out the store, like most people who say, hey, I'm looking forward to coming back. So again, the argument can be made to a jury. It's just in this case, we've got a situation where this isn't a summary judgment.
Your Honor, I did ask her in her deposition. I believe it's in page, I don't remember the page number, but I know it is in there. If she was actually looking at the cashier while talking and leaving, and she does not recall.
She says, I could have been. Line 23, page 53. Answer, I could have been.
Yeah, you could have been. It's equivocal.
But you're saying, you're arguing to the court that's not literally what you just said to the court. She doesn't answer, I was not. She says, it could have been. You asked, were you walking with your head turned towards the cashier? It could have been. It could have been because, I was saying bye to them and, walking out the door. That's what she testifies to.
Okay. All right. Well,
Your Honor, just going back to your points, though, again, there is absolutely no evidence in discovery that would suggest how long the stool had been in its present location. It is just assumption. Yes, plaintiff's counsel points to Ms. Serrano's testimony, but she could not state how long it had been there. Neither could the plaintiff.
But you said in your argument that it essentially was there for 30 minutes. So that's what I'm saying. This doesn't.
So, and I'm making that argument because that is, I think that is what we have to take it, because there's no evidence to say that it had been placed there while the plaintiff was in the store. Even when viewing the evidence,
the lack of evidence is not evidence.
Well, it is whenever it's the plaintiff's burden of proof to show.
I asked the employee point blank, and she says, "I don't know." So.
Yeah. All right. Like I said, I'm going to.
There are a few more issues, though. I wanted to respond to plaintiff's counsel, on, Your Honor. Whenever he points to Ms. Serrano's testimony, I want to point to the court that Ms. Serrano actually did not see. She saw the plaintiff and then saw the plaintiff fall to the ground. She was behind the counter and I don't believe was able to see the plaintiff's feet or see the floor in front of the plaintiff as it fell. And it was only after she came around the counter that's when she saw the plaintiff on the ground and the stool in the area. Plaintiff's counsel brought up the issue of the shopping bag. Again, going back to the distraction doctrine, the distraction needs to be something that is placed there by the property owner, the property possessor. There is no testimony, there is no evidence that the plaintiff claims that the bag was obscuring her view or otherwise preventing her from seeing the hazard. And then just going to just the most important points, a property owner or property possessor is not required under Georgia law to keep the property free and clear of any and all hazards. Because of the static condition doctrine, the prior traversal doctrine, it's only those hazards in which the property owner or the property possessor should reasonably, or believe, with the exercise of due care, remedy those hazards in which the invitee would not be able to discover or otherwise identify. It's usually like the hidden or concealed hazards, because otherwise would make the property possessor, the owner, insurers of people's safety on the property, which is something that Georgia courts just have consistently not been willing to do, because people can fall on the most perfect of floors. So that's all I had, Your Honor. Thank you.
All right, thank you.
Your Honor, I have no other business in front of the court. May we be excused, or may I be
You
excused?
may. Thank you, gentlemen.
Thank you, Your
Thank you, Your
Honor.
Honor.
Have a good day.
You too. All right, the next case on the calendar is Michael Montford versus Stephen Wyatt.
Good morning.
Ace American Insurance and Martin Brower Company.
Good morning, Your Honor. Michael Baskin for the plaintiff.
Good morning.
Good morning. Aaron Toddy here on behalf of the defendants.
Good morning. All right. 1 second. Let me pin these so I can see you all better. All right, so you all are here for a tort claim auto accident. This is case 2024CV01274.
Yes, Your Honor, involving a 18-wheeler.
All right, so this is a motion to strike the answer of the defendant Martin Brower Company. This is, I get that there's a discovery dispute about a video. So go ahead and tell me, because striking an answer is pretty extraordinary remedy. Tell me if there are, tell me, make your case for why that's something I need to do in this case.
Your Honor, thank you. With respect, we have two motions that the court has indicated. One to
motion to compel also.
Right. Starting with the motion to strike, Your Honor. In this case, plaintiff filed a verified complaint. And almost as the court has in its possession, we requested over several months that the defendant provide us a verification from the corporate defendant. At one point, counsel didn't provide a verification for either the individual defendant driver or the corporate defendant. After several months, he provided a verification by the defendant driver Wyatt in his individual capacity, and defendant Wyatt on behalf of the corporate defendant. Now, as noted in the brief, Your Honor, defendant Wyatt is an employee, a driver for.
Okay, so let me stop you, Mr. Baskin, because I kind of want to get to the heart of this. So basically, a lot of the, other than what actually happened on the ground, a lot of the information would have been in the hands of the corporate defendant. Is that correct?
That's correct, Your Honor.
All right. So we're talking about work schedules, training. We're talking about manuals, any videos, any of those things would have been the property of the corporate defendant and should have been produced by the corporate defendant. Is that correct?
That is correct, Your Honor.
All right. So then, why wouldn't a corporate representative have signed the verification, Mr. Patty?
What we're talking about here is the answer, Your Honor, the answer to the complaint. The motion to compel here, I believe, is very narrow, focused solely on the video that was unfortunately not recorded in the cab of the truck. So, and I believe that we've got two separate motions here, and I don't believe that the motions are linked to one another. I don't believe that
Okay.
Mr. Baskin is arguing that the failure to produce documents results in the striking of our answer. What he's arguing is that our verification of the answer, which was performed by the driver, the person with the most knowledge regarding the events giving rise to the lawsuit, is not sufficient.
Well,
But
under the
but
law,
OC
Mr. Baskin, that is sort of on the answer part, sort of an either or. It can be the corporate defendant, or it can be an individual with the, like he says, the most knowledge. So what makes their answer insufficiently verified such because of the driver responding?
Your Honor, under the statute, for a corporation, a person signing on behalf of the corporation, it has to be a director, owner, or such other person that has a proprietary interest in the business.
And the answer was for all of the defendants named. It was one answer for Mr. Wyatt, Ace American Insurance, and the Martin Brower companies all answered together.
Right. He signed, Mr. Wyatt signed on behalf of himself and the other defendants, as I recall. And that's contrary to what the Georgia statute provides. We asked Mr. Wyatt point blank, Mr. Wyatt, are you purporting to be a director of the corporation? No. Do you have any proprietary interest in the corporation? No. Do you have any authority to sign on behalf of the corporation? No. I think that satisfies that he is not the appropriate person to, in fact, verify any factual assertions on behalf of the corporation, Your Honor.
Your Honor, I disagree with that quotation from Mr. Wyatt's testimony. He did not testify that he was not authorized to sign the verification on behalf of Martin Brower. And what I'd like to do is read directly from the statute at issue here. OCGA section 9-10-111.
Any officer or agent who knows or whose official duty it is to know about the matter set out in the answer.
Exactly. Mr. Wyatt was the driver. He was the only Martin Brower employee there at the scene of the accident. The matter set out in the answer involved the accident and his training and education to be a driver. So as a result,
and the company acknowledges that he is an agent of the company.
For purposes of verifying the answer, yes.
Well, okay, what do you mean for purposes of, if we're talking about just because he's verifying the answer, because it says agent, it doesn't say agent for a limited purpose. It says you're conceding that Mr. Wyatt is an agent of the company.
He is.
There's nothing in the statute that says there's some limitation on his ability to speak on behalf of the corporation. It says that he's an agent of the company.
An agent who knows about the matter set out in the answer. Your Honor.
And that would mean, hear me clearly, that would mean that he also knows about those answers that pertain specifically and narrowly and only to the corporation.
Right, because the verification is made by the person who knows those matters or has gathered information to be able to educate himself about those matters. There's not going to be a single person at Martin Brower who knows about every single thing that is relevant in this case.
There is not, but usually there is an officer, usually called a 30B6, who is the person who is designated as the holder or gatherer of that information on behalf of the corporation.
Okay. I understand what you're saying, Your Honor. Two other quick points here. One, a motion to strike an answer is supposed to be filed 30 days after the pleading was served. So the motion to strike here is untimely. Second, the remedy, if a verification of an answer is either not done or is improper, the remedy, it's crystal clear in the case law, and Mr. Baskin has not cited a single case allowing the striking of an answer
Well,
that was verified. The remedy here would be for Martin Brower to amend its answer to provide a verification form.
Yeah, I did say that it would be extraordinary at the least for the court to strike an answer based on that. But the representation that you make that Mr. Wyatt is the person who can represent the company in the answer. Okay, if that's the choice y'all are making, I think it is legal. I don't think that there is a reason, Mr. Baskin, to strike that answer. If they are choosing to have Mr. Wyatt be their agent with knowledge of the ability, with stating that he has knowledge of everything that's represented in the answer, then that's on them. I can't tell them how to litigate their case as long as it's within the bounds of what is statutorily required. And there's no just as Mr. Wyatt can be an agent for the purposes that they're designating him on behalf of the company, there's nothing that says that they also have to designate someone else, even if they're answering for multiple people. I don't see that anywhere. Now, the motion to compel for the video, my understanding, Mr. Baskin, is that there's some allegation that I know trucks, commercial vehicles record. I'm not sure how much of what they do in the normal course of business is recorded, or if there is some trigger to begin a recording, like with the police officers all day, every day. As soon as I turn on my lights and sirens, the video starts playing in my vehicle. When I step out of the car, I activate my body cam. I hear that all day, every day. I don't know what is the trigger for the recording of an incident for a commercial driver. So, Mr. Baskin, tell me from that standpoint why you believe that there exists a video that they're denying exists.
Thank you, Your Honor. And I think the court's question is right on. And Your Honor, I would bring the court's attention to page 3 of our brief. We asked Mr. Wyatt the exact question that the court is posturing. And if I may,
you may.
The question was, okay, now are the vehicles, either vehicle, but specifically the model that back in 2022, would it have been equipped with a dash camera, a video recording device? Yes, sir. All right. And just for the record, tell me, what would that video footage show? Are there cameras on the side, in the front? Where are the cameras located? In the front, facing the driver and facing the roadway. In the front only. Okay. And does the video operate when you're operating the vehicle automatically, or do you have to activate it? It can be manually activated, but it operates on its own. So, Your Honor, he answered that question. When he got into his truck, turned it on, began to drive, that camera was operating. I went on to ask him, did you check your equipment to see if all components of your were working? Yes, everything appeared to be working. So according to the defendant driver, his cameras were working that would have shown how he drove out of that Chick-fil-A into the left lane, coming out, and everything else. And we went on to ask, did you ever retrieve the video or look at the video? And we went through that, Your Honor, and he said that video is in the exclusive province and control of Martin Broward.
Okay.
And I might add, Your Honor, defense came back in its responses. There are sensors on the side of that rig that will detect cars when it gets too close. The defendant came back and said, "Oh, we don't have that. It didn't pick up." Well, that's fine if you didn't have that, but we know you had the video that was running all the time because Mr. Wyatt said that they were two separate and distinct things. The video that was ongoing showing the road as he operated versus the sensors on the side.
Okay. That makes sense. Mr. Taddy?
Yes, Your Honor. So a couple of things here. First off, Mr. Wyatt testified that the camera was operating. He did not testify that the camera actually captured and recorded footage of the accident. There's a distinction here between the camera operating and the camera recording footage. As Your Honor already pointed out, the police officers have the body camera on their vest or the dash cam in the police car, but
Right.
certain events have to occur for the video to actually be recorded.
No.
Well,
Once it turns
well,
on-
in this truck, that's how it is. In this truck,
Okay,
that's how it
yeah,
is.
you can't make that, you can't make that accord with police cameras, because that's what I'm telling you, is as soon as it comes on and it begins recording, that record the police officer never has access to it. It goes into the cloud and it is kept by the police records to be produced later if necessary. Now, some of them never get produced, and there's a retention time where they'll be either overwritten or just thrown out. But the police officer, like as soon as it starts recording, it's gonna capture the event. I don't understand a camera that comes on that doesn't capture. So why is there a dash cam that doesn't capture anything? What's the purpose of that?
The dash cam is operating and has video going through it, but the recording function of the camera is only triggered upon certain events. One, it can be manually triggered in advance. The recording can be manually triggered in advance. That was not done here because Mr. Wyatt didn't have any reason to know or to suspect that he was about to get into an accident. Or when the cab hits something with sufficient force, stops suddenly with sufficient force, the recording function is automatically triggered. That did not happen here because that's not how this accident occurred. Your Honor, we would love to have the video from this accident, because I think it would show that Mr. Wyatt was safely operating the vehicle and was traveling at a very low rate of speed at the time of the accident. The issue here is that there is no recording. Mr. Wyatt in his deposition testimony testified that the camera was operating, that it was working, but he did not testify that any recording was made. He did not testify that there was an existing video that Martin Brower had in its possession, custody, or control. In fact, the questions that Mr. Baskin asked Mr. Wyatt were, this is from pages 57 to 58 of his deposition. He asked him, I'm going back to that video recording device. Martin Brower would have the footage, correct? I object to the form of your exiting out of Chick-fil-A up to the collision, correct? I object to the form. He said, you can answer. He didn't respond. And then he asked, well, let me put it like this, Mr. Wyatt. You don't have that footage, right? And he said, no, sir. He doesn't have, in other words, he's saying he didn't have any video footage. You didn't ever
But he didn't
retrieve that
respond to whether there was footage.
Exactly. He didn't respond whether there was or not. He was saying he didn't have any. In other words, the issue here is, or Mr. Baskin is not does not have evidence that the video footage exists. And the interrogatory response, the verified interrogatory response from Martin Brower says that there is no video.
Who verified that response?
The verification was by, look, it was not Mr. Wyatt.
That was my question.
It was not Mr. Wyatt because he doesn't have knowledge of that, obviously.
Exactly.
The verification was by Paul Bartley, who is one of the local managers here for Martin Brower.
Okay, and what was the question and what was the response that was verified?
The question was, give me just a second here. I will. Well, I think we cited it in our brief, Your Honor. Let me. I did not quote it there. Give me just a second. I apologize.
No problem.
Might want to start with interrogatory number 28.
Yeah, so 26, interrogatory number 26, asks state whether the truck involved in the collision contained or utilized an onboard recording device, an onboard computer, or device known by any other name that records information concerning the operation of the truck. The response was, we raised some objections to that, and then the response was the truck's onboard drive cam was not triggered by the accident. So that's the verified response, Your Honor.
And Your Honor, if I could speak to that, nobody's talking about whether something was triggered by impact. We asked them for the video that was ongoing from the time that defendant drove his truck out of the Chick-fil-A. You don't have to have an impact for the video to show what it shows. That's what we were asking for. We didn't ask him for give us video of the actual impact. No, we didn't. We didn't ask that.
What you're saying, Mr. Baskin, and what Mr. Chatty is saying is that there is a device that records. This was a while ago, but for me, I thought most commercial vehicles will have a device that records throughout. Whenever the vehicle's running, they will record, just because so many different things could happen. There could be a breakdown. There could be a theft or a hijacking. There could be a situation where the truck gets into an accident or runs into, like, the clearance isn't enough and they run into an overhead. So because there are so many things, or because they time the drivers, they sometimes will record them to make sure that they are getting the crew rest they're supposed to get, and that they are driving when they're supposed to be driving. So all of those things. My assumption is that happens, but I'm not a trucker and I don't run a company. So what Mr. Taddy's clients have said is there is a device in the vehicle, but the video wasn't created because it wasn't triggered. Is that my understanding, Mr. Taddy?
That is correct. The video, the video camera was on the dashboard. The camera points at the driver, and the camera points out the front of the vehicle, but it does not record footage record and retain footage unless there's a triggering event, either manually or with an impact.
And Your Honor, here's the rub with that. Here's the problem. Mr. Wyatt himself, the driver of some 20 some odd years, who was driving defendant's truck, when asked specifically, and does the video operate when you're operating the vehicle automatically, or do you have to activate it? It can be manually activated, but it operates on its own, meaning it was operating on its own. You don't have to activate anything. He stated, you don't have to activate anything.
There's a difference between the camera operating and the camera recording the video footage. That's the distinction.
That's a distinction splitting hairs because the video.
Okay, but
that-
Mr. Baskin, they have verified their response. And so I'm required to take as true that they're willing to risk perjury or spoliation and the sanctions that come with spoliation if such a video does exist. At this point, they have verified their response, that particular response to your discovery request. And my understanding is Mr. Taddy's clear that under penalty of perjury, which is a felony punishable by up to 5 years in prison, and also significant spoliation sanctions, that they're saying said video doesn't exist. Now, you want me to compel something that they have sworn under oath does not exist.
I understand the courts.
What you're saying is, I think they're lying, Judge, and you need to compel them. But I don't have any information or evidence that they are in fact lying because they have taken the step to verify their response, so I have to take it as true. Unless you have evidence to the contrary, unless you can come up with something that says they do in fact have the video, and I have new evidence that shows that they have lied to the court, lied to me, done spoliation in this case, then there's nothing I can do because what you're saying is Mr. Wyatt says, oh yeah, you either manually operate it or it operates on its own. But that in and of itself, that speech does not to me say that it operated on its own. What he's saying is akin to what Mr. Taddy is saying is you can start it manually or it can start on its own if there's an event. But I have no basis for compelling them to give me something that they have verified under oath does not exist.
Given that, Your Honor, we would ask the court to give us leave. Let's go back to the verification. If the court is saying that Mr. Wyatt's verification is sufficient.
Okay, listen to me now. Mr. Wyatt verified the answer, which is why I asked about the request for production. Mr. Wyatt did not verify those. The company, the representative of the company verified those.
Yeah, I'm well aware of that, Your Honor. That's not where I was going.
Okay.
Where I was going is we wanted to take the deposition of a 30B6 representative, but we wanted the information from the defendant with what we thought was a appropriate person verifying the answer, right? Thinking that Mr. Wyatt was not that person.
So you're saying you would have deposed the person who verified the answer as the 30B6.
Or we
well, just ask. They have to name. They can name their 30. You can ask them.
They can, but yeah, that's absolutely correct, Your Honor.
Okay, so make them name the person and then depose that person. That the based on the statute, they do not have to be the same person.
That's
the
correct.
Person who verifies the answer. And I get what you're saying is I would have taken the deposition of the corporate body, the corporate person who verified the verified the answer, but you don't have that. So you either get them to name their 30B6 and set a deposition, or you take the deposition of whomever you determine based on the verifications of their discovery. But Mr. Baskin, just because you think they're lying doesn't mean that the court has a basis for which to compel something.
Yeah, and we understand that, Your Honor. And where I was going with it is we'd ask the court to give us leave to complete a 30B6 deposition of.
So that's a motion for an extension of time or additional discovery time. That's not a motion to strike or a motion to compel.
And Your Honor, we would have no objection to extending the discovery period to allow such a 30B6 deposition to occur. No objection.
court will give you 60 additional days for discovery.
Thank you, Your Honor.
60
All
days
right.
from today, Your Honor.
From today, and the motion to strike and the motion to compel will be denied.
Thank you, Your Honor.
You're welcome.
Have a great day.
You're welcome. Take care. All right. So next case on the calendar is Chelsea Cleckley versus Malcolm Pendleton, Kenneth Nash, Century Select Insurance, Aura Express Transportation, KLN Trucking, Progressive Mountain Insurance. This is Mr. Pate.
Yes. Good morning, or I guess we're approaching the afternoon. Good afternoon.
Yeah, y'all be
Judge
patient
Hayward.
with me. We're working through as quickly as we can, but thank you all.
No problem. Yes, Your Honor.
Yes,
All
Your
right.
Honor. Mr.
So Mr. Pate is here on behalf of the plaintiff.
That's correct, Judge.
All right, and is there anyone here on behalf of the various defendants?
Yes, Your Honor. David Restucher on behalf of defendant Kenneth Nash.
And Meg
Mr.
Olson
McKenna?
on behalf of defendant Nash.
Hi.
How are you, Judge?
I'm good. How are you?
I'm doing well. It's good to see you. I
Good to
am
see you
here
too.
for this one on behalf of Century, Mr. Pendleton, and Aura Express.
All right. Mr. McKim used to be in my courtroom.
Ah, nice.
Haven't seen him in a minute. All right. So, okay. This is the case 2025 CV 04361.
Yes, Your Honor.
All right. So this is on the defendant's motion to dismiss in this case. Who's going to argue the motion to dismiss?
I will, Your Honor.
All right, Mr. Pronounce your name for me again.
Restucher.
Mr. Restucher.
Yes, Your Honor. We're here today on our motion to dismiss under OCGA 911-12B6 because the plaintiff's complaint fails to state a claim upon which relief can be granted against Mr. Nash. This case arises from a hit-and-run collision that occurred on March 27th, 2024 on Jonesboro Road in Clayton County, Georgia. According to the Clayton County Police Department and the plaintiff's complaint, all three vehicles were stopped at an intersection on Jonesboro Road. The plaintiff was situated in the left lane, defendant Nash was in the right lane, and defendant Malcolm Pendleton was in the right turn only lane. As the light turned green, defendant Pendleton, operating a tractor trailer for defendant Aura Express Transportation, made an improper lane change from the right turn only lane into the adjacent lane of travel immediately to his left, where Mr. Nash's vehicle was located. In doing so, defendant Pendleton sideswiped the tractor trailer operated by defendant Kenneth Nash and owned by defendant KLN Trucking. This improper maneuver triggered a chain reaction collision that pushed Mr. Nash's vehicle into the lane immediately to its left, occupied at the time by plaintiff Chelsea Cleckley's vehicle, thus causing the collision, which is the subject of this claim. Immediately after the
I'm sorry to interrupt. So
Yes.
contact was made between the defendant's truck and the defendant, Mr. Nash's truck.
Yes, ma'am. Yes,
Okay,
Your
and they were both tractor trailers.
Yes, Your Honor.
Okay, go ahead.
This contact between defendant Pendleton and defendant Nash pushed defendant Nash's vehicle into the plaintiff's vehicle. Immediately after the collision, defendant Pendleton fled the scene without stopping or reporting the accident in direct violation of multiple Georgia statutes. Plaintiff's own complaint acknowledges that both the plaintiff and our client, Mr. Nash, attempted to prevent defendant Pendleton from leaving the scene. Rather than comply, defendant Pendleton responded with aggressive language and ultimately drove away from the scene. Law enforcement later identified defendant Pendleton's vehicle using license plate records and flock camera footage. Despite these admissions in plaintiff's complaint, plaintiff now seeks to hold Mr. Nash liable for negligence, only asserting that Mr. Nash failed to control his vehicle and avoid striking plaintiff's car. However, the plaintiff does not allege any specific act or omission by Mr. Nash that would constitute such a failure, nor does it explain how Mr. Nash could have prevented the collision given defendant Pendleton's sudden and unlawful lane change, which was performed, as the plaintiff herself states, when it was not safe to do so. Instead, the facts as pled demonstrate that defendant Pendleton caused the incident, while our client not only complied with but exceeded his legal obligations. The plaintiff accurately states the applicable legal standard for a 12b6 motion to dismiss in their objection, and the case cited by plaintiff Anderson v. Flake elucidates this standard and confirms that dismissal is warranted when, based on the factual assertions provable within the four corners of the complaint, the plaintiff would not be entitled to relief. Under Georgia law, even with liberal notice pleading, a complaint must allege facts that would make a claim plausible. Conclusory allegations are not sufficient. After devoting most of the complaint to detailed allegations of defendant Pendleton's negligence and his criminal conduct, plaintiff attempts to implicate our client with only a single cursory paragraph. That paragraph merely asserts that Mr. Nash failed to take appropriate evasive action or maintain control of his vehicle when it struck the plaintiff's car. It offers no specifics regarding what Mr. Nash did or failed to do, how any act or omission breached a duty under the circumstances, or even what actions would have been reasonable after being suddenly hit by another vehicle entering its lane. Nonetheless, plaintiff claims this alleged failure entitles him to economic and non-economic damages, punitive damages, and attorney's fees from Mr. Nash. In their response to our motion, plaintiff begins by emphasizing Georgia's liberal notice pleading standard, a point we acknowledge in our motion as a low threshold. While Georgia does not demand detailed fact pleading—
low threshold, but there is in fact a threshold.
Yes, ma'am, and that would require factual allegations that, if proven, would establish a plausible claim. This complaint only offers conclusions about Mr. Nash, not facts. It asserts Nash failed to take appropriate evasive actions, yet it never identifies what Nash did or failed to do, or how any conduct breached a duty. The plaintiff's cases that he relies on, or that she relies on, are entirely inapplicable here because each one of those decisions involve complaints containing specific factual allegations. And in contrast, plaintiff's complaint does not identify any concrete act or omission. The plaintiff's objection contends that their complaint goes beyond mere conclusions by asserting two supposed facts. First, that Mr. Nash's tractor trailer veered into the plaintiff's lane and struck her vehicle. And second, that Mr. Nash failed to control his truck, arguing that these two facts, if proven, would establish negligence. But the first point is not an allegation of negligence at all, and is a mischaracterization of her complaint. The complaint states only that the impact caused defendant Nash's tractor trailer to veer into the left lane, which itself attributes the movement of Mr. Nash's vehicle to Pendleton's initial collision, not to any act or omission on the part of Mr. Nash. It merely describes the physical result of Pendleton's unlawful lane change, which the plaintiff herself admits caused the chain reaction. The second, more tenuous argument conflates a legal duty with a factual allegation, stating that Georgia law requires drivers to maintain control of their vehicles or take evasive action after being struck is merely a broad characterization of a duty. It doesn't constitute a factual assertion demonstrating how defendant Nash breached that duty under the circumstances. Even worse, the plaintiff relies on the co-defendant's answers in their objection, claiming their statement that Nash failed to take appropriate evasive actions proves that the plaintiff has a viable claim. That argument fails for several reasons. First, a co-defendant's admissions in their own answers do not cure deficiencies in the plaintiff's complaint. The court must evaluate the sufficiency of the plaintiff's pleading, not what the other defendants allege in response to pleadings. Second, even if those statements were considered, they are themselves conclusory and lack any factual detail. And finally, and most importantly, the co-defendant who caused the incident and then fled the scene, even as the plaintiff and defendant Nash attempted to stop him, has every incentive to shift blame and argue that fault should be shared. That's not evidence, that's a litigation tactic, and it can't substitute for the plaintiff's obligation to plead facts showing negligence by our client, defendant Nash.
Okay. Mr. Pate?
Yes, thank you, Your Honor. And just to address Defendant Nash's points that he's raised today, paragraphs 45 through 50 of the complaint spell out exactly what happened and what Nash failed to do. The complaint alleges that after being sideswiped by Pendleton's truck, Nash's tractor trailer veered left into plaintiff's lane and struck the passenger side of the Kia Sorento that plaintiff was operating. It further states that Nash failed to maintain control of his vehicle and failed to take proper evasive action to avoid striking plaintiff, and that these acts and omissions directly caused plaintiff's injuries. This is more than sufficient under OCGA section 911-8A, which requires only a short and plain statement of the claim showing that the pleader is entitled to relief. Your Honor, as you know, Georgia's standard for dismissal under 911-12B6 is among the most stringent in the country. The court cannot grant dismissal unless the allegations in the complaint disclose with that the plaintiff would not be entitled to relief under any provable facts. And that comes from Anderson v. Flake, which I cite in my brief. That's 267 GA 498. That's a 1997 case.
Mr. Pate, can I ask you a question? So my staff attorney and I were talking about this when we were preparing for the hearings. And what I pointed out to her is there's a difference between if it was a a rear end collision. So if Mr. Nash is in the front, Miss Cleckley is in front of Mr. Nash, and Mr. Pendleton is the third vehicle. Mr. Pendleton smashes into Mr. Nash then smashes into Miss Cleckley. Mr. Nash has the ability to control the space between himself and Cleckley. He has, in fact, not just the ability, but a duty to maintain a distance between himself and Cleckley such that he can avoid an accident, colliding with her by being able to stop in that distance. Even if you're struck from behind, if you put your brakes on, I'm going to stop before I hit Cleckley. In an instance such as this, where Mr. Pendleton is in his lane, Mr. Nash is in a parallel lane, Miss Cleckley is in a parallel lane to Mr. Nash and Mr. Pendleton. Mr. Pendleton then veers over, pushes Nash into Cleckley. There is no control that Mr. Nash has between the distance between his vehicle and Cleckley's vehicle. Where is his duty to save space or to stop a collision if he is, in fact, if the impact is not his initiated by him, but by someone else?
Well, Judge, we don't know what Nash did in response to that contact. And so Nash's tractor trailer veered left into Mrs. Cleckley's lane and struck her vehicle. That fact alone, that his commercial motor vehicle entered her lane and caused a collision, is enough to state a claim for negligence under OCGA section 4648. That's the section for failure to maintain lane and the general duty of care imposed on all drivers. The reason why Nash lost control, which is what we're arguing, is really a factual causation dispute. And we can't resolve factual causation disputes at the motion to dismiss stage of this case. Whether Nash lost control, whether he overcorrected, whether he failed to brake, didn't maintain a proper lookout, or wasn't properly trained, is precisely the kind of fact that will be developed through discovery. And so if there's no issue of disputed fact developed through discovery, then that can come up at the summary judgment phase. But what we're looking at right now is just the four corners of the complaint. Does the complaint allege enough facts to state a
Yeah,
claim?
but here's the thing. Anybody can allege anything. But at the point where you make these allegations, if there's no basis for them to result in a possible recovery based on those allegations, then Nash still has to defend and put money forth for the defense that is going to end up, when I get to the summary judgment point, unless y'all develop way more than what I'm seeing now in discovery, Nash is going to have to stay in the case and spend money to defend, because y'all are just alleging that there was, through some miracle or some ability to drive better, when Pendleton struck his vehicle and pushed him into Cleckley's vehicle, there was something he should have done.
Right. And but Judge, that's exactly what discovery is for. And that's why I need to take Nash's deposition to figure out, did Nash properly control his tractor trailer, or did he make an improper maneuver from the lane that he was in into the lane that was occupied by plaintiff? And that's what discovery is for me to develop facts to figure out if his response to Pendleton moving over into his lane and initiating contact, was his response to that, was that proper? And so that's what discovery is for, and that's what we're trying to flesh out and trying to determine. And that's why it's not proper at this stage of the case for the court to grant a motion to dismiss in favor of defendant Nash.
So Mr. Rechiker, what he's saying is, at this point, Judge, this is not right for your decision. Let us discover more stuff and see if there is in fact a duty that he breached with respect to his position in the collision before I can make a decision.
Your Honor, I would aver that plaintiff's counsel is conflating the fact that damages occurred with the fact that there are any factual assertions on behalf of defendant Nash that would give rise to an action against defendant Nash. They're describing a duty, and discovery can't be used to find a duty, but only to show evidence that would prove factual assertions as outlined in the complaint. I don't see any factual assertions alleged against defendant Nash. I only see broad descriptions of duty, and it seems like there is some sort of res ipsa loquitur kind of argument here, but the fact that he veered into the lane proves that that somehow a duty was breached, but they're not describing what that duty was or what Nash did or didn't do that would have breached that duty. And as such, they're not making any factual assertions against defendant Nash, and it's just restating.
Yeah,
the
fact of notice pleading means that that even if you're going to say the cause of the damages to Cleckley's car was the collision between Nash and Cleckley, but what we have to get to is whether there was any breach of Nash's duty, because the proximate cause of the entire collision is likely the actions from Pendleton when he struck Nash. Nash struck Cleckley. Had Nash not been there, Pendleton might have just gone past Cleckley and she never would have been hit. But the fact that Nash was where he was and Pendleton struck him, then he struck Cleckley. So I get that Nash may have been a necessary part of the causation. However, I don't know that the complaint states a duty that he had to avoid the collision.
So he has a duty to maintain control of his vehicle. And if he doesn't maintain control of his vehicle after a sideswipe collision happens, then he has breached his duty of care that he owes to Mrs. Cleckley. And so that's the facts that we allege in the complaint, that Nash failed to control his vehicle and avoid striking plaintiff's car. and that his negligence caused plaintiff's injuries. These are not conclusory statements. This describes the factual sequence that happened in this chain reaction collision. And Judge, right now we're having to fight against arguments made by Defendant Pendleton that Mr. Nash caused a collision. And so that's why I think all of these issues are, they're not appropriately resolved at the motion to dismiss phase of this case. There needs to be discovery conducted. These issues are better raised at the summary judgment phase, not at the motion to dismiss phase. We have asserted facts that if, for example, Judge Hayward, that Mr. Nash testifies during a deposition that he did not react properly to this initial collision, or that he didn't even experience an impact that happened between Pendleton and the tractor trailer that he was operating, then that's going to raise issues for us in discovery. So we need to flesh these out, and we need discovery depositions to happen. And that's why I don't think that this is a case that needs to be dismissed at the motion to dismiss phase.
Your Honor, I would respond by saying, not only is this just a statement of a duty, it's an incorrect statement of a duty. If we had pushed the plaintiff into the wall, would then the plaintiff be liable for her own damages because she failed to control her vehicle? Failure to control a vehicle, as elucidated in various Georgia statutes, is when a driver veers into another lane out of their own negligence, not because they failed to respond with enough time as a result of a collision and not veer into someone else's lane when they were doing everything else that reasonably.
Yeah.
Your Honor, I was just to say, just briefly, from the perspective of Mr. Pendleton, our position is that Mr. Nash was in some measure responsible for the accident. I think the assumption that he was fully out of control of his vehicle and therefore the second impact occurred, that is the question. I mean, our position is that the question of whether or not there was an impact between Pendleton and Nash in the first place, or whether it was an evasive maneuver that caused the collision with Cleckley, is at issue. So that, from our perspective, the fact sequence doesn't end with our collision and then everything else is fallout. Mr. Pendleton's position is that he didn't believe himself to have been in an accident. He continued, and that is, again, there's fact discovery to be conducted. I think tomorrow we're set to take a deposition of Mr. Pendleton, or to have the deposition of Mr. Pendleton taken, at which point, obviously, our position will be further fleshed out.
Yeah, and Judge Hayward, this is exactly what plaintiff is faced up against. Is Defendant Pendleton is denying that a collision happened between his tractor trailer and Nash's tractor trailer. The contention is going to be that Defendant Nash swerved into Mrs. Cleckley's lane and that no impact happened. And so we need to ask and depose Defendant Nash about it, whether there was an impact or whether he evasively veered left into Mrs. Cleckley's room, and if by doing so he failed to maintain a lane. And so that's why these issues need to be fleshed out in discovery, and that's why these depositions need to happen.
Okay. All right, we'll get you guys in order. And as soon as we can. Thank you all. Good to see you, Mr. McKim. You
Great
can
seeing
visit
you,
more
Judge.
often.
I'd like that.
I mean, I haven't seen you since you left.
I don't get to court enough.
See, look, I told you if you were in my courtroom, you would do probably all the in-court litigation you would ever do before you switched over to civil.
Yeah. There's good memories, Judge. That's for sure. Had to dust
All
off the seat
right.
for this, though.
Well, I am glad. My best to your family.
Thank you.
All right,
Great
thank you,
seeing you,
Judge. Oh, you
All right.
excused?
Take care. Thank y'all. It's been a pleasure.
Thank you.
All right. So the next case on the calendar is Valor Holmes versus Shoshana and Rodney Brown. Shoshana Moore and Rodney Brown. So who's representing Valor Holmes? Who's representing Valor Holmes?
Over. I saw the gentleman here earlier, but he's gone now.
He's still here. I don't think he.
Okay, yeah, Mr.
Mr.
Reginald.
Valor Holmes, I need your video and audio.
Looks like say connecting now.
I'm sorry.
I saw on the bottom it said connecting audio for his side. I don't see his face yet.
Okay.
And good evening to you, Judge.
All right. Good afternoon. Is someone here on behalf of Shamet and Reed?
Scott Bushnell here, Your Honor.
All right.
That's about a 2-minute argument.
All right, Mr. Bushnell. Mr. Bushnell's on behalf of Brinkley, Alfonso Brinkley. Is there anybody here on behalf of Shamet Reed?
Here, Your Honor.
Here in the courtroom. Mr. Okay, Mr. Reginald, try to work out the tech issues because I heard you earlier and I muted you, but I don't see mute now, so it looks like you're trying to connect. All right, so who's here on behalf of Shamet Reed?
I'm representing myself, Your Honor.
And you are?
Shamet Reed.
Who? Okay, so on my calendar it says you have counsel. Where's your counsel?
I don't have counsel. I'm supposed to be pro se.
Who's Afiro Obaseki, Randy Williams, and Patrick Calvo?
That was my previous counsel when we were in magistrate court, but they didn't present any of my evidence.
Okay, you do not have them anymore.
No.
You're proceeding pro se.
Yes.
Okay, and this is an appeal from below.
Yes.
All right, Miss
Bushnell.
Miss Powell.
Yes, ma'am.
All right.
What's the question, Judge?
I was just asking if all of the appeal requirements were met.
Oh, yes, her costs were paid. In this instance, the issue is whether or not the appeal form that she used should be allowed to stand. But in the our system, it shows as a petition for review. She used like one of the old outdated appeal forms. But I think that the petition to review.
Yeah, if she got it from the clerk's office, I don't care.
Okay.
It is what it is.
You know, I filed the motion because I didn't think that the form used was correct. I'm not going to waste a ton of the court's time on it. I know that some judges are being persnickety about these, and some are like, saying we're supposed to. So,
by virtue of the fact that they would allow her to even speak it and have a clerk write it out for her, or she could appeal it by writing it on a piece of paper, it doesn't really matter to me, the form of it.
Okay.
As long as she met the other requirements.
That's fine. I'm not going to waste the court's time further on it. There is what I would say is Mr. Brinkley filed an appeal of the exact same thing. And so I think if I didn't file a motion to join the two together, the court needs to join the two together. Just because it's the exact same case. It's just she appealed it, I appealed it.
Okay. All right. So y'all want a de novo review of the magistrate court's decision?
Yes, ma'am.
All right. So I would assume that Mr. Brinkley was the landlord?
No, this is a contractor situation. My client's a contractor. Ms. Reed hired him to do some work.
All right. So Ms. Reed, tell me what work you hired Mr. Brinkley to do and what was or was not done.
So, Your Honor, It's my understanding was all we were here on was on the motion to dismiss, not to have a full-blown trial on this case.
All right.
Because that's
Lots of things flowing.
I'm trying to check the language of the Rule 9 sign now.
Rule 9 says the respondent filed its motion to dismiss. Parties are called before the court for oral arguments on November 12th.
Okay, I see it.
Yes, sir. I could have maybe been clear, but I think the intention of that was that the motions before the court, the notice of appeal and the motion to dismiss would be taken up before the court today.
So my understanding is this was heard in magistrate court and the magistrate court rendered a decision.
Correct.
And then it was appealed to state court.
Correct.
Okay. And you're filing a motion to dismiss what?
I filed a motion to dismiss her appeal as not having been properly filed.
Okay. So that is going to be denied. What else is pending?
That's it. It's my understanding that then we would just need to have the de novo trial of the matter before the court.
All right.
With the two cases combined.
Okay. So your appeal was about the form of the appeal. And Ms. Reed, your appeal was for the actual appeal of the magistrate court's decision.
Your Honor, both parties appealed the judgment.
I got it.
Neither side was happy with what they got.
Okay, so let's hear it. So, ma'am, tell me what happened that landed us here. What did you hire Mr. Brinkley to do? And what was or was not done per the contract?
I'm sorry, Judge, you cut out.
I'm sorry. So my understanding is there was a contract between you and Mr. Brinkley.
And Your Honor, it's my understanding of the statute that if the court's going to have a trial and it's a de novo appeal, we have to have the witnesses and everybody to appear. It was my understanding today was just the argument on the motion to dismiss. My client is not on the Zoom, and I didn't prepare for an actual trial.
All right. So Miss Powell, what's the quickest we can get them on for a trial? And Miss Reed, you can come by Zoom. I see you came to the courthouse, but do you have the ability to Zoom?
I do, but I have my witness here. I was prepared for trial today.
And the knee side, the Rule 9 side does not say trial. It just said the appeal, Miss Powell.
The language is parties filed its notice of appeal or the petition for review on July 11th, 2025, and respondent filed its motion to dismiss on July 22nd, 2025. Parties are called before the court for oral arguments, just generally, on November 12th, 2025. Intended to take up both motions today, but it was not.
Yeah, the appeal is on there, Mr. Bushnell.
Well, Your Honor, when I see oral argument, that just means that the attorneys are going to argue, not that there's going to be a full-blown hearing on this.
Okay, so because you're not ready and because there could be some discussion about the court's language and its Rule 9 side, Ms. Reed, we're going to set the earliest appointment. You and your witness can appear by Zoom.
Judge, we can try to get them. We could push for December if you'd like, but January is more likely.
If we need to, we can put them on like a Tuesday afternoon, just that one case.
Okay.
The only thing I would state, Your Honor, is I do have a leave of absence in for December.
No, we're talking about putting it on as soon as I can. So December, like early December or late December, when's your leave?
My leave is the 6th through the 9th. So I would be available effective December 10th.
Okay, so whatever the next Tuesday is after December 10th, Ms. Powell. And Ms. Reed, my apologies for the way the NISI was stated, that you were prepared for what I was prepared for, but I didn't state it properly such that Mr. Bushnell put his client on notice, which is why I'm stating when I'm going to set it on a day when I don't normally have something. So I'm going to make a special setting for this case because you came all the way to court. You and your witness can come by Zoom from wherever you are. That's fine. And we'll go ahead and get notice out to you again. Okay.
Yes, Your Honor, if I may, I will not be available December 15th.
Okay, that's good. Thank you.
The 15th to the 19th, I will not be available as well.
15th
And
to the
then I
19th.
also had a book of evidence for each party.
Oh, that's fine. You can file that with the clerk of court and we'll image it. So when you go downstairs, just file it with the clerk of court. She will image it and I'll be able to pull it up.
Thank you, Your Honor.
No
Judge, could we
problem.
do next Tuesday if you wanted to hear it immediately? I don't know how many witnesses Mr. Bushnell has, but that way it really can be immediate. We could
Yeah,
do it
that's
after
fine.
our jail calendar. So in the afternoon.
Good, Miss Reed?
That's perfect.
Okay, what time? We shooting for 1 or 2?
Let's do 2 to be safe with the jail calendar.
Yeah.
It's a large jail calendar that day. I just want to bring that to y'all attention.
Okay, so you think 2 is better, Miss Val?
Yeah, 2 probably would be better.
All right, thank you. All right, 2 p.m. next Tuesday.
And then the only thing is if Miss Reed, if you could work with the deputy and just chat your email, that way we can send you the order by emailed service.
Yeah, just give Deputy Castro your email and she'll chat it to Miss Powell.
Okay. And who should I send my exhibits to prior to the hearing so that you
You
have?
can file them electronically and they'll come to
Okay.
me. We'll be able to pull them up.
All right. We will get that done.
Yeah. But Miss Reed, before you leave court today, when you go downstairs, go to the first floor to the state court clerk's office. Go ahead and file your exhibits under this case number. And this is the case, Scott. I know there's 2 pending cases, but I want to make sure this is the case number 2025 CV 04975.
Okay. If possible, could I actually show up in court next Tuesday?
Yes, ma'am, that's fine. We'll be here too.
I would.
Yeah.
I think it would just be easier if we did this one in person, Your Honor. I have no problem with that.
That's fine.
All right.
All right. You're both excused at this time. We'll see you next Tuesday after the jail calendar.
I appreciate it, and sorry for the confusion, Your Honor.
Oh, no problem.
Have a good day.
All right. Take care.
Bye-bye.
Okay, so that was the 7th case on the calendar. Then there's the 8th case we did already. So the 11 o'clock calendar, I'm sorry I'm running behind, but these cases take time. So I will move as quickly as I can. The first case on the 11 o'clock calendar is Gregory Fisher versus Joseph Jones and Palmetto Automatic. Anyone? Oh, this case number 1 was excused.
Excuse me, Your Honor?
Yes, I have the
Well, Judge, yes, the first case was excused, but did we go back to Valor Homes?
Oh, I'm sorry, we didn't go back to Valor Homes. Mr. Reginald, unmute for me.
Yes, ma'am, Your Honor.
All right, what's your last name, sir?
Reginald Campbell.
Okay, and is Valor Homes a company?
Yes, ma'am. I'm the
Okay,
agent on behalf of Valor Homes.
Okay, when state court, if it's a company, you need an attorney to represent the company. This is an LLC, so it would in state court, it needs a company to represent the company. I mean, an attorney to represent the company.
Oh, I mean, because I'm the agent on behalf of the company, and I handle all of the cases in magistrate court and.
I get that. In magistrate court is fine, but when you're an LLC or any type of corporate structure, you need it. If there's a case, I forget the case, but you need an attorney to represent. Like individuals can be pro se. Individuals can be pro se in magistrate court and in state court, but companies have to be represented by attorneys in state court. Hold on one second. Is this about the current case, Ms. Powell, or is this something else?
No, ma'am, the final 11 o'clock.
Yeah. Okay, and also there was a bankruptcy case that was filed.
Yeah, yes, it was a bankruptcy case that was filed, and I filed a motion into the bankruptcy court to be relieved from stay, and they relieved it and remanded back so we could actually file the eviction procedure.
Okay, do you have that document, the remand from the bankruptcy court?
Yes, ma'am. I put it into the file. Yes, ma'am.
Okay, Ms. Powell, do you see that?
Let me check now.
All right, and while Mr. What's your
Campbell?
last name? Campbell.
Mr. Campbell.
Mr. Campbell, definitely I'm going to have to reset to allow you to get counsel because you cannot represent Valor Homes as an agent.
Okay.
And Judge, I do not see it in the record. I see a one-page complaint that makes note of the bankruptcy case, but does not prove the bankruptcy case.
Also, I need the bankruptcy case information that allows me to proceed because I can't proceed if there's a bankruptcy pending. Now, Ms. Moore and Mr. Brown.
Yes, ma'am.
If you have been in this place, let me tell you what Georgia law is. If you've been living in this home and you haven't paid the rent, he's entitled to possession of his property. As long as you're in possession of the property, rent has to be paid, even if there's defects, even if there's things that he hasn't repaired. We can do an offset of the amounts that you paid to fix things, but you can't just hold over in somebody's property and not pay them. And then file the bankruptcy. And I'm just going to be honest with you. When I did this in magistrate court, people would file bankruptcy all the time just to give them more time. But look at it from this standpoint. If you had a house and somebody was living in your house and you still had to pay the mortgage and you couldn't make any money off of your house because people are living for free in your house, how would you feel?
That wouldn't say well with me.
Because nothing in your answer has presented any legal defense that you have to keep you from being evicted. This is all just stalling techniques. And I suggest, I know it's hard out here, but you got to understand, it's hard out here for everybody. Just because he has the ability to have a home that he rents out doesn't make him rich. Because most people who rent property have mortgages. So he's got to pay a mortgage. You're not paying him any rent to be in the property, and he's still going to be out the money it takes for that property. So it's a situation where I have to be fair to both parties.
Okay, well, Your Honor, I didn't go so far.
Hold on, Mr. Campbell.
Yes, ma'am.
In what was said, but me and Mr. His last name is Mr. Limo. We actually had a working situation going on when I first moved onto the property. And then very soon after I moved onto the property, something happened and that was dissolved. So I was trying to work with Mr. Limo on
when it gets to court, all I look at is the paperwork. If you have a lease, how much you were supposed to pay, how much hasn't been paid. So y'all can work anything out up until the point that something gets filed. When something gets filed, I don't have to understand. Y'all had a conversation. We talked about this. We agreed on that. If it's not on paper, I don't look at it. I'm required to see what's in the four corners of the document. Did you?
And that's why I said I didn't add that information in there, ma'am. I apologize for that.
No, I don't need it. If y'all agreed on something, because that's not what the lease, y'all would have had to put it in the lease and both of y'all sign off on it.
Okay, I understand you now.
Yeah, all of this stuff about, well, we work this out and work that out, if it's not in the lease. But please understand, I understand it's hard out here. Nobody wants to be evicted, but also nobody wants to sit and have property that somebody's living in for free. You're depriving him of the money for his asset.
Yes, ma'am. Yes, Your Honor. Yes, Your Honor.
All right, so we'll reset this to the December calendar. Mr. Campbell, if you come back without an attorney, the case would be dismissed. Ms. Moore, Mr. Brown, if y'all can work something out in the interim where you leave, because let me tell you, if I hear the case and it is sufficient that that a writ be issued, I can only give you 7 days.
Understand.
I can only give you 7 days to leave. What I would suggest is you start looking to leave now. Because
Yes,
my
Your Honor.
understanding from the filings is y'all are $25,000 in arrears.
Yes, Your Honor.
And like I said, just because he has the ability to provide a house for people to rent doesn't make him rich. So the law, every time y'all live there a month and he doesn't get paid, you're taking money out of his pocket. You get it?
Yes, Your Honor.
All right, so we'll reset this case for the information from the bankruptcy court for Mr. Campbell to get an attorney for the corporation. And then when we reset it, I'm going to hear it fully as if it was newly presented to me. But I promise you, my limitation is I can only give you 7 days to leave the property. If you know that, and between now and the time I reset this case and hear it, you may want to make some moves.
Jan, I got one question.
Yes, Mr. Campbell.
Yes. Can the owner himself attend instead of an attorney?
No,
Okay.
Mr. Campbell, once you set up a LLC, once you make it a corporation, corporations need attorneys.
Okay. All righty. Thank you so much, Jan.
You're welcome.
All right.
All right. So that case will be reset. So for the 11 a.m. calendar,
Okay. So we'll receive that reset through the mail, ma'am?
you will.
Thank you so very much. And it's okay for us to go?
You may.
Thank you again.
All right. So Fisher is excused. That's on the 11 o'clock calendar. Wells Fargo Bank versus Catherine Atkins. Anyone here for Wells Fargo?
Yes, good afternoon, Your Honor. Colin Demianchik for Wells Fargo Bank.
All right, Mr. Demianchik, and anyone here for Ms. Atkins?
I am here, Your Honor.
All right, so Ms. Atkins, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, so this I understand is a contract. It's a case on account, Mr. Demianchik.
That's correct. Yes, it's in regards to a credit card account.
All right, go ahead, sir.
Yes, Your Honor. This is we don't believe it's too much at issue here. We received defendant's answer with some hardships they did identify, and we're certainly sympathetic to those. But as far as legal defenses, we do not believe there are any pled at this time, and that the defendant's answer would warrant a judgment for the pleadings for the amount sought in the plaintiff's complaint, which the complaint was also included in an affidavit at the time of filing attesting to the damages, so they are liquidated at this time. We're seeking that principal balance at the time of charge off, which was $8,277.61. We are also seeking attorney's fees not to exceed $800 and costs of court of the current action.
All right. So, Ms. Atkins, what Mr. Damianchik has stated is that your defenses, even though you filed an answer, none of the defenses were legally sufficient to keep the court from awarding a judgment in this case. A hardship is not legally sufficient. Difficulties or financial difficulties is not legally sufficient. What the court is going to do is to present a judgment, and then you can work with Mr. Demianchik's client on maybe a payment plan after that.
Okay. Okay, I understand. Now, I have a question because I'm in the process of filing bankruptcy. Can I include this in my bankruptcy?
I don't do bankruptcy, ma'am. I don't know what you can include and can't. I would ask your bankruptcy counsel, or I would ask the bankruptcy court. I don't know why it wouldn't be, but I don't know.
Okay.
And I will just briefly state too, if a bankruptcy is discharged, Ms. Atkins, we'll take all the necessary steps to be in compliance with the federal bankruptcy law. If we need to satisfy the judgment afterwards, we'll just have to review the filings once it's discharged.
Yeah, so they will work, if you file a bankruptcy, they do whatever they need to do after that. But this court doesn't consider that.
Okay.
All right. So I'm going to go ahead and grant judgment in the amount of $8,277 and how many? Oh, and 61 cents.
Correct.
Plus $800 in attorney's fees, plus court costs as against Ms. Atkins in this case. All right. So Ms. Atkins will get you a copy of that. Mr. Demianchik will get you a copy of it. I'm presuming that you filed it with the affidavit.
So that'll come in the mail?
Yes, ma'am.
Okay. And then I contact Mr.
Okay, so this is what I say. The judgment is going to come from the court. It'll come in the mail, but you are always free to contact Mr. Demianchik's client to see if you can set up a payment plan to pay the judgment. That's something that you all can work out. And
yes, and our contact information should be on the pleadings you received, Ms. Atkins. If you want to give us a phone call, you can talk. Wells Fargo will want you to discuss it through us since we're going to be in custody of the judgment, basically monitoring it. So just give us a call, and we'll be happy to try and get some kind of resolution in place.
Yeah, because sometimes that's more helpful than if they pursue the judgment and they take assets when you're not ready for them to take them. If you can set up a payment plan, it may just work better for you from that standpoint. Okay.
Okay. All right.
All right, but that's between you all. All right, so you're free to go at this time. Thank you. The next case on the calendar is Citibank North America versus Shelley Wilson. I have Kezia Drake Akulo for Citibank, unless there's someone sitting in for Ms. Akulo. So ladies and gentlemen, when you come to court, please put your first and last name on the screen. It doesn't help me if I just see a first name because we're conducting business and business is usually done on a last name basis, Mr., Ms., and last names, so that doesn't help me if you just come as Shelley. So is there anyone here on behalf of Citibank North America? Is this Mr. Green's case? Because he said he had to step out.
No, Judge, that's not my case.
Okay. All right. This is the last call for case 2023 CV 03562 Citibank North America versus Shelley Wilson. All right, Ms. Wilson, the case is going to be dismissed for warrant of prosecution.
Okay.
Because the party that's prosecuting the case has not appeared.
Okay. Thank you so much.
All right, but ma'am, that doesn't mean they won't come after the debt. This is a dismissal for procedural reasons, not on the merits of the case. So if I were you, I'd govern myself accordingly, okay?
Okay.
All right, thank you, ma'am.
Thank you. Bye-bye.
Bye-bye. All right, number 4 on the 11 o'clock calendar is
excused.
Oh, excused. I'm sorry. Assurance America versus Kosia Coleman. That case is excused. The next case is Twin City Fire Insurance versus Janelle Miranda. Twin City Fire Insurance.
Yes, Your Honor. Jim Johnson on behalf of Twin City.
All right.
This is on our motion for default judgment. We filed an affidavit this morning. I was going to have a live witness to testify about damages, but she is not available. So we got an affidavit and filed that this morning regarding the amount of the damages paid. We also filed an affidavit of non-military service.
All right. And is this a subrogation case? Or?
Yes, ma'am.
Okay. So Janelle Miranda, last call for Janelle Miranda. All right, so Mr. Johnson, tell me how much we're asking for in that case.
We're asking for $100,867.41. I will waive any claim for attorney's fees and costs.
Okay, so I have $100,807.41.
$867.
$67.41. Yes, all right, and you're waiving court costs and attorney's fees?
Yes, Your Honor.
All right, so the court is going to grant the amount in default of $100,867.41. And Mr. Johnson, I'm presuming we have that order with
Yes,
record.
we submitted a proposed order with the.
Okay, we'll sign it and get it back to you.
Thank you very much, Your Honor. May
All
I
right.
be excused?
Yes, sir. Thank you.
Okay, thank you.
Root Insurance Company versus Corey Williams.
Daniel Green for the plaintiff, Judge.
All right, for Corey Williams, I don't see Mr. Williams, and if the courtroom had him, they would come on and tell me. So last call for Corey Williams. So Mr. Green, this is liquidated.
Yes, Judge. We submitted an affidavit. The balance that we're seeking is $23,632.68. No, I'm sorry. Scratch that because there was some offset. So we're actually only seeking $10,678.98 plus the court costs. So that's $10,678.98.
All right. So in default, the court is going to grant the amount of $10,678.98 plus court cost.
Yes, Judge. Thank you.
Yeah, and this is on the case 2022 CV 00545. All right. Thank you, sir. Mr. Green, you have anything
Thank you.
else for me?
You too. No, thank you, Judge.
All right.
Sorry,
Next
I'm in Fulton County. They're doing some sort of celebration. I don't know what's going on.
That's okay. I can only hear you, really. I can't hear the
Okay,
background.
good. Thank you.
You're welcome. All right. Tammy McDuffie versus Donna Tench. This is an accident case. Who's on behalf of Miss McDuffie? Is that Miss Parnell Vasquez?
Yes, ma'am.
All right. And Miss McDuffie is present.
Yes, her thing is listed as Tammy Ray.
Okay. And is there anyone here on behalf of Donna Tench? Last call for Donna Tench. All right. So Miss Parnell Vasquez, you can swear in your witness and I'll hear testimony.
Okay. Tammy, raise your right hand. Do you solemnly swear the testimony you're going to give today will be the truth, the whole truth, and so help you God?
Yes, ma'am.
Okay. So, Your Honor, a brief opening statement here. We are here for the damages portion of this hearing today. The liability has already been decided. Ms. Tench did not answer our demand or our responses, our answers in the court, the lower part of the court. If I can give a brief opening statement, this involved Miss Tammy here was at the Walmart on Anvil Block Road picking up her prescriptions, and she realized that she did not have her driver's license. So she left the Walmart, exited onto the side area of Grant Road, and approached the intersection of Anvil Block Road with a vehicle in front of her. Ms. Tench was making a left turn onto Anvil Block Road, and after the vehicle that was in front of Ms. Tammy passed, Ms. Tench turned her SUV right into the side of Tammy, who was on a motorcycle. She hit her on the left side of her body, not just the motorcycle, but her personally. So she broke her leg, and then the bike was knocked over. The mirror on the side of the bike on the right side went into her ribs and broke her ribs. She was under the SUV. Fire department personnel arrived, the police arrived, the statements were taken. The ambulance, of course, needed to transport Ms. Tammy quickly because of her injuries. And so the officer never actually got Tammy's statement. He issued a citation to Tammy, and he also issued a citation to the other driver. The witnesses said that the other driver turned into Tammy, but there was a mistake in the police report that said that they were both trying to make a left on Anvil Block Road, but that's not completely true. And Tammy didn't get to give her side of the story. She was going back to her house on Forest Parkway. And if you look at maps, you will see that Anvil Block Road was not a turning point for her to be on that road. So she was then transported to Grady Hospital, where she was admitted on the 7th of December of 2022. And she was released on or about the 15th of December of 2022. And so, and I apologize, I did upload some exhibits to the case, but I didn't realize that until today that I needed to do that. So those have been submitted, but I haven't gotten the acceptance from the court back saying that they've been stamped. So I don't know if you can see them in the file or not at this point, because I haven't submitted them, but I haven't gotten the stamped response back. So Tammy underwent some surgeries while she was in the hospital. We have gotten the billing records, which I'm going to ask Tammy about in a few minutes, that show the hospital records from Grady Hospital and also from the physicians that treated her there. So, and she's going to be able to testify to the damages and the pain and the suffering that she suffered at the scene of the accident, and then from that point forward. So as of next month, it'll be 3 years that she has been dealing with these issues that she experienced during this motorcycle crash. And then I'll go through the billings with her and then go over the damages at the end, if that's okay.
All right, I'm ready.
Okay, so Tammy, we've already determined that we've stated your name, Tammy McDuffie, and do you live in Clayton County?
Yes, ma'am.
Okay, and can you describe to me the day of the accident? Can you describe to me what you were doing that day?
Yes, ma'am. I had just my roommate now, but he had just finished doing a couple tweaks on the motorcycle that I was purchasing, and and I decided to go to Walmart to pick up a prescription that had been there, and I figured I could do it was a short drive and a good test drive to see if I was going to finish making the payment to purchase the bike. And so I got to Walmart, and that's when I realized I did not have my ID because it was a narcotic that I needed it. So I left Walmart, and I was actually sitting at the red light on Grant Road, Old Grant Road. And when the light turned green, the car in front of me went ahead and went. And I'm a really cautious driver, especially on a motorcycle. And I saw headlights coming behind me, so I was checking to make sure that they were slowing down. And I looked to my right, but as soon as I looked to my left, as I was going behind the car in front of me, it was so fast, like she was already there. There was really nothing that I could do if she didn't hit her brakes or anything. It was a little crazy, and the next thing I knew, I was like on the pavement and pretty much pinned under my bike for a minute. I did kind of try to wiggle out, but I was in and out of consciousness too. So it's hard to say, what'll happen, first. Or the last thing I remember seeing were her headlights and the person driving on the telephone.
So you physically saw the other driver on the telephone?
She was holding the phone with her right hand.
Okay. And so what happened what do you remember next? You said you were on the pavement and trapped underneath your bike in the car. What happened at that point?
I had tried to get my body out from underneath the trapped out from under my motorcycle, my right leg.
Mm-hmm.
But I knew as soon as I started moving that my left leg was broken because I could feel it like kind of dragging.
Mm-hmm.
And it wasn't until I'm pretty sure that I fainted because I had a full face helmet on and I couldn't lift my visor on my helmet, and I couldn't catch my breath. I couldn't get a good breath of air. So I'm pretty sure that I lost consciousness then. But when I regained consciousness, I actually had to use my right hand to get my visor up, but it wasn't until I actually got my helmet off that I could, catch a good breath of air. And so I do remember, and plus I couldn't see until I actually got my helmet off my head. So really all I could see was feet and hear voices, and but I do recall a female. I couldn't tell you what she looks like or any of that, but I just do remember her apologizing and saying that she didn't see me, and a male voice also approached and was asking if there was anything he could do. I had my work phone and my cell phone on me at the time, and I was trying to get in touch with my roommate and try to call my kids because I'm a single mom with 5 kids, and it was just a little blurry after that. But there was a gentleman that was helping me to make those phone calls, and that's when I realized that my wrist was also broken because I couldn't hold the phone or any of that. So, and I'm pretty sure that it was actually the gentleman that was in the vehicle with the lady that hit me. And I'm not sure, but that's what my roommate says because it wasn't long after that I made the call that he was there because it's just a mile, like a literal just a mile from the house. But I do remember the paramedics showing up, them asking me my name and if I knew where I was, and of course they did that actually several times, and I'm guessing the only reason that I keep getting replays of it is because I kept losing consciousness, and because it was pretty bad. It cracked my helmet from the front all the way to the very back, all the way down the middle. So.
And so were you, can you describe like the pain that you were in at that point?
Everything hurt. Everything hurt. My wrist hurt, my leg hurt, and it hurt to breathe. I believe they gave me an IV laying. I'm not sure if I was on the ground first or they cut my clothes. I do remember it's kind of all blurry right now. I don't remember a whole lot at the hospital except for actually asking them. I was, of course, laying there.
Well, Tammy, I'll get to the hospital in just a minute. Your Honor, can I share my screen for the exhibits?
You may.
Okay. Okay. All right. Tammy, are you seeing the police report on the screen?
I am trying to zoom in so I can. I don't have my glasses on right now, so it's kind of small. Okay.
Okay. So this is the police report that I've marked as Exhibit A, that shows Donna Tench is Unit 1 and Tammy McDuffie is Unit 2. Do you see that?
Yes, ma'am.
Okay. Does this look like the police report that I showed you on a previous date as being the police report from your accident?
Yes, ma'am.
Okay. Your Honor, I don't think there's a whole lot more that we need to discuss with this. She's kind of talked about this, so I would like to submit Exhibit A into the case record.
It will be admitted without objection.
Thank you. All right, I'm going to stop sharing the screen for that one. Okay, so now, Tammy, I want to go to I also want to share my screen. I want to show you pictures of the motorcycle. Let me get that pulled up.
On that one that you just showed, where it shows us kind of going head on,
yes,
isn't accurate at all.
Okay. Explain that, if you will, why that's not accurate.
Okay, because like I had made it to almost the center of the intersection, and once I got to where the car in front of me was, and there was a vehicle behind me. When I looked over to my left and saw her, she hit her her actual vehicle hit the left side of my body. So it was more of like her coming into my mid part of the motorcycle.
Okay. All right. So not a
Does
head-on
that make sense?
collision. Yeah. So not a head-on collision, a turning collision.
Right, right.
Okay. So on the screen, do you see some photos that of your motorcycle here?
Yes, ma'am. Yes, ma'am.
Okay. Did you take these photographs?
Yes, ma'am.
Okay, and I've just put them into this screen for the ease of the court. This very first one here, this shows this one. I don't know if you can see me moving the cursor, but
yeah,
can you kind of describe what each of those pictures, like what damage that depicts?
Okay, yes, ma'am. The first one here that you had your cursor surrounding it, that's actually the left side mirror. And I do believe, yeah. And what usually is below it would be the blinker, but it's no longer there either. And I do believe on the one that's on the bottom, right next to, yes, that one.
Okay.
Trying to see if that is the right side mirror or this still the, okay, that's still the left side mirror. And I was trying to see, I don't believe that there is a right side mirror anymore because of one, the bike slammed into the ground. It was that, and I cracked 4 of my ribs on the right side, and it was from the handlebars or the mirror.
Okay.
From the right side of the motorcycle.
Okay.
But there was not a whole lot of damage done to the left side, just mainly the right side from it slamming down onto the pavement.
Okay, and that's depicted here in the headlight, the scrapes on the headlight?
Yes, ma'am.
Okay.
Yes,
and then the fender here is dented on the left side, which that would be from the impact some way.
I do believe so, or being underneath the Tahoe itself.
Okay. Okay, Your Honor, I would like to submit this as Exhibit B into the case file.
Will be submitted without objection. You can submit them as a group. Is that your intention? These are the group?
Yes, so this
Okay.
is just the one page with I just put the screenshots on there so you could see it easier.
Yes, that's fine. Each of the pictures will collectively be known as Exhibit B without objection.
Thank you.
Mhm.
Okay, so now, Tammy, we're going to go to, let me stop sharing my screen for a minute. Now we're going to go to your trip to the hospital. What do you remember about that part?
I remember actually that is when I do remember kind of encountering the police. I do remember speaking to one when they were putting me on
the stretcher.
That really hard. Yes.
Okay.
Thank you. And I'm not sure. Sorry about that. I'm not sure if it was the same officer that was beating on the ambulance door as it was the one that I had spoke with, because I'm not real sure how many were there, but I know that they got there a lot later than the paramedics did, and I was already in the ambulance. But they had asked me the same questions as the paramedic as to my address and my phone number. I'm not sure what all else that they asked, but I do remember when they were trying to decide what hospital to take me to. My roommate was actually in the front of the ambulance when he did get out and to stay there because of the officer that was beating on the door, the back door of the ambulance. He said that, Miss McDuffie, do you know your license is expired? And I told him yes. And the paramedic was just really telling him that we need to hurry and get her to a trauma unit. And I can't remember if that's when they gave me the pain medicine or it's kind of just blurry, but I know that my roommate didn't make it back into the ambulance. And I know that they were going to let him take the bike back to his house. And until they pulled it out from underneath the Tahoe, the gas line actually came off. So it was then a potential hazard. So they had to tow it. And that's about
Okay,
the
so
gist of that.
let's talk about when you went to the hospital, you went to Grady Memorial Hospital, correct?
Yes, ma'am.
And what do you remember from that, your time at Grady? Because you got admitted on the day of the accident, and then I show
Yep.
that you got released. Do you remember the date that you were released?
I believe it was a little over 2 weeks. So I'm guessing the 15th or so. They
Okay.
were going to put me, it's hard to say because they postponed the surgery for my wrist. They were going to put titanium in there. And as you can see, I have limited, use of my wrist now.
Which
It will only turn
which
my
wrist?
left one.
Okay, and are you
That's as far as
right-handed?
I can turn it.
Are you
I'm
right-handed or left-handed?
ambidextrous. I do a lot. I write with my right hand, but a lot of, my extracurricular activities I do with my left, or did with my left hand.
Okay. And so they were
But
going to do surgery and then they postponed the wrist surgery. Why? Do you remember?
twice. They didn't ever say. I'm guessing they were pretty busy. I'm not sure how long I stayed in ICU. It was pretty much a blur. I do remember when I first got there that I was kind of just laying there naked for a long time, and all I had was the coin, the full body armor coin that I was telling you about. I had, and I just wanted to make sure that it didn't get lost. And they told me that was okay, that I could keep it and hold it in my hand. And I remember waking up right before they put me into this tunnel thing. Um, and they said that if anything was, going on with my brain, or if I had like any serious like damage to my brain, they would be able to tell with the machine that they were putting me into.
So is that an MRI?
I guess so.
Okay, well,
I'm
you're
not really
describing a
sure.
tube, so I'm thinking it's
Mhm.
probably an MRI. Does that sound right?
Yeah, yes, and it's really loud.
Okay. And then so what all did they find when they put you in the MRI? What kind of injuries did you do you remember having?
It's a concussion, like uh, a slight concussion, a broken wrist. My wrist was broken, and my leg was broken, and then there are 4 cracked ribs on the right side.
Okay, so
I
what
pretty
part
much
of your, I'm sorry, go ahead.
go ahead. Go
What
ahead.
part of your leg was broken? Do you remember?
It's the bottom part, the tib tibula, is that right?
Okay. All right.
And it was broke both bones.
Okay. And did they do surgery on that?
Yes, ma'am.
Do you
They
remember
did.
anything about it? Okay, go ahead.
I believe they did it that night.
Do you remember anything about that?
Yes, I actually woke up during that surgery, and it was really awkward and hard to explain. I'm not sure if it was when they were putting the rod in my leg or what. I just remember hearing the doctor saying, "Oh my gosh, she's awake," and they gave me some more drugs to put me back to sleep.
Okay. So did they put,
It was kind of weird because I didn't. Go ahead.
okay, did they put you said rods in your legs. So what all did they put in your legs?
I believe it's just a rod that went into my it goes from my ankle at the I want to say the rotator part of my ankle and all the way up to the rotated part of my knee.
Okay, and did they put plates
I'm not
and screws
sure
in there? Did they
that
put?
I'm not really sure, but it has like uncontrollable spasms at times that just are crazy. They're
Okay, so
you could be standing up. Go ahead.
all right, I'm gonna share my screen again, and this time I'm gonna show you the hospital bills. So do you see this thing that says your name at the top and says medical bills on it?
Yes, ma'am.
Okay, so this is a computation that I made for your total medical specials. Does the number $220,929.92, does that look familiar to you?
Yes, ma'am.
Okay, so we're going to go down here to this first bill here, the Clayton County Board of Commissioners. This is for the EMS bill. Do you remember seeing this bill for your transport to the hospital?
Yes, ma'am.
Okay, and that's $1,710.
Yes, ma'am.
Okay. And then this next bill is for your Grady Hospital. Have you seen these bills before?
Oh, yes.
Okay. So this first one is for an attending physician for the amount of $35. But then as we move down, these are all from the 8th, imaging, that sort of thing, for $10,647. And then this is the main bill. This is the one that started on the 7th when you were transported and arrived at the hospital. Do you see on here can you see like on line 3 where it says ketamine?
I do. Yes.
Okay. And then further down, you see x-rays and that sort of thing of all the different things that you had x-rayed in the MRIs. Do you see that?
Yes, ma'am.
Okay. And then this is several pages worth of treatment. And so do you see in here tramadol, gabapentin, oxycodone?
Yes, ma'am.
Okay, and all that, and fentanyl. Do you recognize those as pain medications?
Yes, ma'am.
Okay, so you were on multiple pain medications. Is it safe to assume that you didn't remember much of what happened at the hospital?
Yes, that's very safe to say. At least for the first 7 days, I don't remember a whole lot at all.
Okay, so in this bill continues, and there's another page of it. Finally getting down here to the bottom of the list, and $191,991.92. Do you see that amount on there?
Yes, ma'am.
Does that seem like that was the bill that you remembered getting from Grady Hospital?
Yes, ma'am.
Okay. So now we're going to go down here a little bit further. There was some additional visits that were charged separately for $682. And this is for the treating physicians again for imaging. And then now this bill with the blue on it, this is for $16,546. Do you recognize this as a bill for the physicians that treated you at the hospital?
Yes, ma'am.
Okay. So if we take all of these into account, and there's several pages of them, that's what leads us to the total here at the top. I'm sorry, let me spin back up here to the top of the $220,000, $220,929.92. Is that correct?
Yes, ma'am.
Okay. Your Honor, I'd like to submit Exhibit C into the record for medical bills. I can't hear you. You're on mute.
You may. That will be admitted without objection.
Thank you. Okay. All right, Tammy. So now I want to go into, we've already talked about the pain that you experienced during like right at the accident, during the accident, and at the hospital. So can you talk about how this has changed your life since then? I mean, what kind of things do you experience on a daily basis now?
Pain in my leg, just random. This is as far as I can move my left wrist and turn. It doesn't turn like it's supposed to. And I mean, I was supposed to have surgery on here, but whatever Grady did, they had set up something for me because I didn't have any health insurance at the time. So it was a big big problem, but they helped a lot. They set up some sort of insurance plan. I'm guessing it was the healthcare, uh, marketplace healthcare or something along those lines. Or if the lift that was actually coming to pick me up after, they discharged me, which they were going to, it was my understanding they were going to release me into a rehab center because I couldn't take care of myself. I couldn't go to the bathroom. I couldn't walk. I couldn't even wipe. So I'm sorry.
That's okay.
It's really, it's hard just remembering. I do remember one thing waking up while I was in the hospital, and that was my mom and my brother were actually had come to see me, but that was like 7 or 8 days later. But that was all. And they had contacted my roommate and to let them know that I was going to have to go into a rehab or something. And that's when he came up there and signed some papers that he would take care of me. And so I wouldn't have to go into a rehabilitation center.
Is that your roommate or your brother who signed the papers?
My roommate.
Okay.
My roommate now.
And so do you have permanent scars and permanent markings to show where this accident occurred?
Oh, yes, ma'am.
Okay.
So
do you think that your pain levels will improve? I mean, it's been 3 years since the accident. Do you expect your pain levels to improve in the next few years?
No. The spasms are a little better. There's no telling, when they'll come, and there's no control over them. And even with the I think it's gabapentin and the skeletal nerve pills that they have me taking don't help the spasms that much. But when it's cold and it's really cold, I can feel the titanium in my leg, and it's hard to bend my ankle. It only goes, to do a squat now is just, it's very painful. I do push myself because I have 5 kids and 12 grandkids. So I do push myself a little far. With my wrist now, I don't even know if I'm going to be able to ride my bike again. So I haven't tried yet. I am going to because I love it. It is part of me. It was my way of, that's my therapy as a mom. It was just riding has always been, I've done it since I was a little kid. It was always something that me and my family always did together. But I will have to get back to you on that if I can ride again. Because I don't know if my wrist will allow me to pull the clutches and all that stuff. So.
And Tammy, how old are you today?
47.
Okay. Your Honor, I have an Exhibit D for the annuity mortality table from 1949. I'm sure that you're familiar with this. I would like to submit that as my Exhibit D. I did attach it to the case file.
Exhibit D will be admitted without objection.
Thank you, ma'am. So now I would like to talk about the damages portion, just a closing statement and with the damages. I think it's pretty clear that the motor vehicle crash that Ms. Tench caused injury to my client. She's expressed pain and suffering from the time of the accident through now and for the foreseeable future. So what we would ask for is, the number that I'm asking for is $2,648,929.90. That includes the past medical specials of $220,929.92. For the past 3 years, pain and suffering, $250,000 a year, which is $750,000. And then going with the her current age at 47, and the mortality table is 33.56, and multiplying that times $50,000 per year for future pain and suffering, that would be $1,678,000. And so those numbers added together would be $2,648,929.90. And I would submit that we have presented enough evidence for that to show that she exhibited this pain and suffering, and these medical bills were valid for the treatments that she had while she was at Grady.
The court has listened to the evidence presented. There's been no evidence to contradict the information presented. The court will the court will grant the amount of $2,648,929.90 plus court costs.
Thank you, ma'am. I had one other issue that I would like to bring up to the court. As we discussed, Tammy was issued a citation for having an expired motorcycle license. I truly believe that, yes, the law says that you're not supposed to operate the motor vehicle with the, expired license. She has a hearing with that in front of you on the 17th at 10 a.m.
That's mine too?
Yes, ma'am. That's why I'm bringing it up with you.
Okay.
So I would argue that the officer was going with the letter of the law, not the spirit of the law. And
well, okay, but I think it would be more appropriate to argue the criminal case in the criminal context, because the state does have the right to be heard.
Okay.
And so here, arguing it here with me is going to be ex parte. So I can do one of two things. I don't think I have heard the case, but the state does have the right to know that I've heard the civil part of it, and to object if they wish to my hearing the criminal part of it. If they wish to have me recuse and move it to another judge, I can do that. But to have you argue that now would be inappropriate.
Yes,
because
yes,
the state does have the right to be heard on that.
I understand. We are not actually representing Tammy for the criminal part of it. I was just trying to handle part of it for her and just ask simply for a dismissal based on all the things that have gone before.
I get that, but I can't grant a dismissal without the presence of the state and the state being aware of the case, because they are prosecuting the case. And so as much as I have to balance the equities, as it were, that's not a technical legal term, but a term of art. They have the right to be heard and to weigh in on whether they believe I should still hear the criminal matter, since I've had the civil case and heard that which they were not a part of, and two, they have the right to respond to whether they wish to have the case dismissed or on that ground. So at this time, the court will hear all of that information at the time that the citation comes before me.
Yes, ma'am.
All right. All right. So thank you. You all are excused at this time. We'll go ahead and sign off on the order.
Could plaintiff counsel submit a proposed order?
I'm sorry. Say that again, Ms. Powell.
I just asked the plaintiffs if Ms. Vasquez, if you would submit a proposed order for this.
Yes, ma'am, I can.
Thank you.
All right.
I have a question.
Yes, ma'am.
The 17th is be a Zoom call also, or do I have to go to the courthouse?
Is the 17th my arraignment calendar, Miss? Is that a Thursday?
It's a Monday.
Monday's usually video. You have a video option.
Yeah.
So look at your Rule 9(i).
Yeah.
Look at the notice that you got that says for you to come to court. Though usually those are on video hybrid calendar, so you could come in or you could do video.
Yes, it's the same.
Yeah, so you can come in video. All right.
It's soon.
Thank you.
Okay, and I'll get that proposed order submitted soon.
All righty, thank you.
Thank
All right,
you.
the next case on the calendar is Delta Community Credit versus Jade Redding and Jasmine Thomas.
Good afternoon, Your Honor. Attorney Terkessa Manigo for the plaintiff.
Good afternoon, Ms. Manigo. Anyone here on behalf of Flade Redding or Jasmine Thomas?
Yes, ma'am.
All right. All
Hello,
right.
Your Honor.
Ms. Thomas, my understanding is this is a contract case, meaning that there was a possibly a credit card or some account evidencing a debt, and they are pursuing collection of that debt. Am I correct, Ms. Manigo?
Yes, Your Honor.
All right. All right.
May I say something really quick? Ma'am,
No, ma'am.
did you say Jade?
I said Flade, Flade.
Okay, my grandmother is right here. She
Oh,
doesn't
okay.
have a Zoom, so she's here with me.
That's fine.
Okay.
Because both of y'all are listed.
Yes, ma'am. I just wanted you to know.
Okay, thank you. All right, so Ms. Manigo, so here's Ms. Thomas and Ms. Redding. This is case 2025 CV 04325. The answer that you filed talked about hardship and the inability to pay because of a hardship. What I can do is put you in a breakout room with Ms. Manigo to see if you all would want to agree to possibly a payment plan if her client is willing to do that. So Ms. Manigo, would that be something your client would entertain?
Unfortunately, Your Honor, being that this is a credit union and their rules are a little bit different than typical banks, they explicitly have instructed me that I have no settlement authority today and that I have to move forward with this. I'm sorry, I would if I could.
No problem. I understand, and I have been in that position when I practice where the client gives me instructions. So I always ask. So Ms. Thomas and Ms. One second. Ms. Redding. So here's the thing. When you answer it, the answers that you present to the court have to have a legal basis for me to take action. So just based on a financial hardship, like I took out the loan and now I can't pay it back because of finances or my inability to pay, that's not a legal defense. So you would still owe the debt and the court could still hear the case and present a judgment. Now, once the judgment is granted, then you have the possibility, because Ms. Manigo says she has to seek a judgment, but she didn't say that she's prevented from talking to you once she has a judgment about how it's paid. Is that true, Ms. Manigo?
Yes, and being that I am appearance counsel, she would have to contact the attorney of record that's on the complaint and all of the documents there. But that's correct. They would be able to talk to her after a judgment is granted.
All right. So I'm going to let Ms. Manigo present her case. Yes, ma'am.
I wanted to say something to the letter, to what you were speaking on.
Yes, ma'am.
It's not that it is that I can't pay now, but it's not that I want to. Like, I've always maintained a 760 credit score, but I've been waiting on court for 2 years for Clayton County. And with court pending, I've missed out on Fortune 500 jobs, a lot of jobs, great jobs. And I've been working since 10th grade. My last job, well, I was making $37 an hour, but due to other court things that I had going on, coming from a bad relationship and an ongoing custody battle, it has put me in a predicament to not be able to maintain what I worked hard to obtain in life. And now I'm here, and it's not just because I'm sitting around and I just choose not to pay them. I want to pay them, but it's
Ms. Thomas, this is not a character issue, because most of us are closer to being homeless than we are to being billionaires. Yeah. 1 or 2 paychecks or a medical situation, any of us could be in a situation where we're unable to pay what we normally would pay. So it is not a character judgment. It is that I just need to explain that because your answer is based on a hardship, that is not a legally sufficient answer in order to dismiss the case. Okay.
Okay.
But I'm not judging you from that standpoint, because every one of us has the ability to find ourselves solvent one day and insolvent the next, depending on how life turns.
Yes, ma'am.
Gotcha.
Yes, ma'am. I did go to court with you guys in November. So they gave me an option to take a class, but the class is also $600 and I haven't been placed in it yet. And I've been waiting for it. So I
I
will
got
be
you. Well,
back on
that
track for
might be
payment.
another issue. I'm not sure that that's with me, but that might be
Yeah.
another issue. And then you can just kind of work that out. But let me
Okay.
let Miss Manigo present. But
Okay.
I don't want you to feel like I'm judging you in any way, because like I said, debt happens. It is the way this country is set up. Debt happens. If you want to have something, people get into debt. So that's not an issue for me. Miss Manigo.
Yes, Your Honor, and I think this will be a pretty much a straightforward case. I based on the explanation that you did provide, that I was going to start with, that hardship is not a legal defense to debt owed in the state of Georgia, and I would like to say that while we are sympathetic, definitely, to the defendant's hardships, that is no legal defense. That being said, we're here seeking granting of the summary judgment, the motion for summary judgment that was previously filed into this case. That is based on primarily that there's no disputed material facts in this case. The defendants have not stated in their answer that they did not apply for the loan with Delta Credit Union, that they did not receive the loan, use the loans for personal reasons, and that then they defaulted on their requirement to maintain the minimum monthly payments on the loan. As such, when they failed to maintain the minimum monthly payment requirements after a certain amount of time, and there was no communication from the defendants, the plaintiffs charged off and accelerated the debt due under the contract. And that was on or about March 31st, 2025. The current outstanding balance owed on the contract is $32,826.26. In response to the plaintiff's complaint, in response to, yes, our complaint, the defendants filed an answer in which they did not refute any of these contentions that I just expressed, nor, that they failed to make any required payments thereunder, nor that they caused us to suffer a hardship in the amount of just stated of the $32,826.26. The second point that I'd like to address is the uncontroverted record evidence establishes defendant's breach of the contract and plaintiff's resultant damages, entitling the plaintiff to a judgment as a matter of law. Just quickly, under Georgia law, the elements of a right to recover for breach of contract are breach of the contract's terms, damages that result to a party who has a right to complain of breaking the said terms, and the uncontroverted evidence and testimony of record established in this case shows that we are entitled to a judgment as a matter of law. We have filed into the court as supplemental documents with this case a sworn affidavit from the plaintiff from Delta Community Credit authenticating this debt. Also, the original contract that was filed in as Exhibit 1 to the affidavit, and a transaction history, which was filed in as Exhibit 2 to the affidavit. Also, Georgia law provides that a fact finder may not disregard the evidence of a witness or witness that is also submitted through documentation unless that witness is to be impeached or the documentation impeached in some manner by law or disputed by some other evidence. Being that that's not the case in this particular matter, we would ask that the evidence be relied upon. Here, the plaintiff has presented direct, uncontroverted, credible, and unimpeachable testimony of existence of a valid contract between the parties, defendant's failure to abide by the repayment terms of the contract, and the plaintiff's resultant damages. As a result, we feel as though the plaintiff has established a prima facie entitlement to summary judgment. In conclusion, again, just to, I hate to just keep repeating the same facts, but they're pretty basic here. The plaintiff has showed uncontroverted and reliable record testimony and evidence to establish the defendant's breach of the contract and the plaintiff's damages. Therefore, the plaintiff would respectfully request that this court grant our motion for summary judgment on the issue of the defendant's liability for the breach of the contract, and also to award damages sought of $32,826.26.
Okay, no attorney's fees, just court costs?
Yes, Your Honor.
All right. So the court is going to grant the judgment against Ms. Redding and Ms. Thomas in the amount of $32,826.26 plus court costs. And as I stated earlier, Ms. Thomas, you and Ms. Redding are always able to speak with the creditor regarding payment or payment plan or any plans to address the indebtedness. Now that the judgment has been issued, we'll get you a copy in the mail, and we'll get a copy to Ms. Manigault on behalf of the client that you're representing. Okay.
So we have to just get with them to try to make a payment plan, and
you can. It is not. I mean, that is up to you. It is a possibility that exists. That's all I can tell you. But now that the judgment has been issued, they have legal means of collecting on a judgment. And what I tell people is, if you agree to how you pay versus them just coming after you for the payment, it is the difference between you knowing what's going to come out of your monthly ability to pay versus being surprised by something coming out of your checking account, savings account, work.
Garnishment.
Yeah. So they have the ability to, through several means of collecting on the debt. It's just sometimes works better for people if they communicate with them.
Okay. Can I say something for the record?
Yes, ma'am.
I was paying all of my payments on time until I was jobless.
I got that,
and
ma'am.
I
And that's
did reach out to them several times to get in programs and a lot of things to.
I got that, but I don't control how they respond to you.
Okay.
Yeah. Some creditors may want to get, talk with you and get payment up front. Some creditors go to court and then try and get payment on the back end. I don't control how they do it as long as they do it legally.
Okay. May I have the name of the person that I'm supposed to get in contact with?
Yes, Your Honor. I can put that in the chat for Ms. Thomas.
So Ms. Thomas, she's going to chat it to you. Make sure you write it. You know how to use the chat function?
Yes, ma'am. I'm in here right now.
Okay. Make sure you write it down before you leave, because once you leave and Ms. Manigault leaves, you may not be able to access it. Ms. Manigault, you from South Carolina? Because that's the only place I've heard that name.
Yes, I was born in South Carolina, Your Honor.
Low country?
Yes, my mother's from Georgetown area. And
my mama lives in, she did live in Allendale. Now she's in Mount Pleasant. She's in, it's Mount Pleasant, but it's one of the little off of Rifle Range Road.
Yes, I'm very familiar with that area.
Yeah, I figured that because when I heard Manigault, I was like, that's the only place I've heard that name.
Very unique to that area.
Yeah. All right. Well, thank you, ma'am.
Thank you. And after I put this information in the chat, may I be excused?
Yes, ma'am. Miss Thomas, Miss Redding, you're free to go at this time. Hopefully you all be able to work this thing out, okay?
Yes, ma'am.
I wish you well, Miss Thomas. Miss Thomas, it is not a character flaw. It is life happens. And just like life can happen, you got enough time for life to get better. It will get better.
I started good though.
But that happens to everybody. You get ups and you get downs. That is life. I promise you. I promise you. I was going along fine, working fine. And then I had a child who, was medically fragile. And so I couldn't work for a while. And so things happen.
Yes, ma'am.
But it's not that you will not recover from it. If you have the intention to recover, you will. Okay.
My law enforcement on pause. I'm barely paying my rent. It's bad.
I know, but determination, when somebody is determined to do something, even though it's hard to get up that mountain, you will make it to the top because you are determined. And you will have step backs. There will be rollbacks. There will be steps back and then steps forward, but you will get there. Okay.
Yes, ma'am.
You just cannot despair. You just got to keep being positive and knowing that you're going to make it.
Most definitely.
All right. All right. Take care. Thank you. The last case on this calendar is Citibank North America versus Sherry Newman. Citibank North America. Anyone here on behalf of Citibank North America? Okay, somebody has two devices open, and because you have two devices open, it's going to give me improper feedback. All right. So anyone here on behalf of Citibank? Ms. Newman is present. This is the last call for Citibank. Ms. Newman, Citibank, let's see. This is on case 2022 CV 01551. The plaintiff did not appear, but this is the garnishee's motion to open default and modify a default judgment. So you're requesting
Leave that alone, Mike. I don't want this shit.
Okay, Mr. Z, Michael Z, who are you, ma'am, sir? Hello? Okay, I'm gonna mute. All right, so ma'am, you're asking that a garnishment be opened. I'm sorry, default for the underlying judgment be open so that you can address that, correct?
You talking to me, Your Honor?
Yes, ma'am, Ms. Newman.
So
you filed, you're the garnishee in this case, and you filed a motion to open default and to modify a default judgment.
Yes, because I've been paying them every month, August of 2022.
Okay, so I'm not sure. All right. There's two tracks that these cases go on, and I hate it because a lot of times people don't understand. What will happen is the creditor will file a lawsuit. But while they file the lawsuit, they will also be talking to you about payment. So they'll say, hey, let's work out a payment deal on this, and then you can get this debt paid. But in the meantime, they're also going to court. If you don't respond to the court because you think I'm talking to them, I'm working things out, what will happen is they will still get what's called a default judgment, meaning you didn't file an answer after you were served with the court case. And I get it because it makes sense. Hey, I'm talking to them every day. I'm working on a payment plan. I'm paying them what I can pay them, but they're still pursuing this court case. You got to respond to both. In fact, the priority is the court case, because whether you talk to them or not, the court case is still going on. And if you don't, oh, there you are. If you don't pay attention to the court case and respond timely to the court case, they can get a default judgment and still be talking to you about working this out and taking payments. Now, your payments will reduce the amount that they get a judgment for. They will have to offset the amount and continue to decrease the amount so until you get what is called a satisfaction of judgment, meaning everything's been paid. But they can do both. Talk to you on the phone and say, hey, let's figure this out, and also file a lawsuit.
Okay, so basically they have the opportunity to garnish my wages right now.
Yes, ma'am. If they got a default judgment, and it depends on, like, did you sign a consent? Did you work out anything with them where you signed something like an agreement with them?
No, ma'am.
Okay. So a consent judgment would point out how the money is to be paid. So you would say, I consent that I owe this debt and I'm gonna pay this amount of money per month. And they say, we'll accept this amount of money per month to satisfy the debt that we have. We're in agreement. But if you don't agree, then they can get a judgment and pursue it through whatever means are legally available to them, including a garnishment.
Okay, so there's nothing I can do right now, even though
Yes, ma'am.
even though I've been paying every month for the last 3 years.
If you have been paying every month, you can ask for an accounting to figure out where you are and how much you owe, because they should be taking, even if they garnish your wages, if you're paying, they should be crediting you that amount also.
Okay, so basically right now I just need to call them and make some type of arrangement if that's necessary. I mean, if they're
You are always able to call the creditor. I can't tell you what they will do.
Okay.
But what I'm saying to you is what you're asking me to do, I cannot do, because I cannot disturb the underlying judgment based on what you've told me.
Okay. I don't remember getting a court document saying for me to go to court. That's what I was saying as well.
Okay. So you don't believe you were properly served?
I don't remember getting a court date for that, for this.
Okay.
I thought it was just, I mean, what I got, it was from them.
Okay. Did a sheriff's deputy come or a marshal come and serve you with papers or leave papers at your home?
No, ma'am.
Miss Powell, can you pull the service document on this?
I'm checking right now, Judge.
Okay.
My system is not.
I think the reason the plaintiffs didn't show up is because they know legally I can't do what you're asking me to do. So they didn't even show up.
Okay.
Okay, it just pulled up. It says that Miss Newman was served. The street is San Gabriel on November 8th, 2022, personally.
So that says somebody handed you paperwork.
They didn't. Not me. Nobody handed me anything.
Okay. You would have to go to the court that issued the judgment in order to fight that. So service is always a defense to a judgment, but you would have to fight that in the court that issued the judgment, not here with me, because I'm dealing with the garnishment, not the judgment.
Just for the record, we did enter the judgment. I don't know if a separate motion needs to be filed, but the judgment did come.
Yeah, it does. It would have to be filed in the case that the judgment is in.
Okay.
Now, let me be clear that the document that they filed saying that they served you is what's called a rebuttable presumption. It means that once I see that, I can legally presume that you were the person who was served. If you are going to challenge that, you have to present evidence that it was not you. So the burden would shift to you to present evidence that that was not you who was served.
Okay.
Okay?
And just for the record as well, I know that evidence has not been submitted, but this garnishee's motion to open and modify default judgment did come in under the same underlying case, just for the record.
Okay, so this is not under the garnishment case?
No, ma'am.
All right. So, because it's termed garnishee's motion. So Ms. Newman, do you have anything that says that you weren't the person served on that date? Like, do you have a witness? Do you have somebody else who accepted service? Any evidence that would disturb that service presumption?
No, I don't.
Yeah, see, usually
wasn't nobody.
What's
You
what?
said what, ma'am? I'm sorry.
I'm just
sorry.
saying that once they present, they serve you, they're required to file a notice of service with a return of service with the court. And so that says, this is what we did to serve her, and we're letting the court know that she was served on this date, and this is how we served her. Meaning personal service, they went to your house or wherever you could be found, work, house, wherever, and they handed you documents from the court. Now, a lot of times people don't understand it's from the court, it's not from the people themselves.
Right.
So that's how this case was initiated. In order to overturn that, you would have to give me some evidence that shows that that wasn't you. And it has to be more than you just saying it wasn't me.
Okay. I mean, I don't know who else, like, okay, I don't know. It wasn't me, so I mean, I don't know what other evidence I can get if I didn't get the paper. So
did you live there at the time?
Yes.
Did you live there alone?
No, I live with my kids. Me and my kids.
I can't tell you, like, if you hadn't lived there, that's possible, but you said you lived there at the time. So the court, the presumption still remains that you were served.
Okay. All right. Well, I'm just gonna reach out to them and see what I can do on that behalf, on that, with the creditors as well, because I've been paying them faithfully for.
I got you.
3 years.
Ask them to account for how much you pay, because you should be paying down your debt. And if you're paying down your debt, then at some point in the foreseeable future, there should be, you know, a resolution.
Right.
Okay.
All right. Thank you.
All right, Ms. Newman, thank you. All right. So the next calendar is the 1 p.m. calendar. Thank you, ladies and gentlemen, for your patience. These are civil calendars, so, you know, it depends on what we have to talk about. Some of them stretch out a little longer. Geico General Insurance Company versus Colleen Cole. That case was dismissed. And the Hertz Corporation versus Aranthea Denise Brown. Hertz versus Aranthea Denise Brown. Last call for Hertz versus Brown. Okay, that case will be dismissed for want of prosecution. All right, the next case on the calendar is Santander Consumer USA versus Michael Matthews Jr., and an imposition and or. So Mr. Lightman, is Mr. Lightman present, or somebody here on behalf of Mr. Lightman?
This case was excused as well.
Okay, so case number 3 is excused. Mr. Matthews, this case was removed from the calendar, so you're free to go at this time.
Judge, just since the defendant did appear, the case is removed, but an order will be filed as needed, just to make note.
All right, so Mr. Matthews, then order is going to be filed. My understanding is they dismissed the case.
Okay.
All right.
No, they did not dismiss the
No,
case.
I'm sorry. That was the other one. That was the other note. I'm sorry. An order will be filed for the dismissal for want of prosecution.
Okay, so
An order will be filed for the dismissal of want of prosecution in 2019 CV 00032. And in this case, the court is going to grant the motion for contempt because the turnover has not happened.
Wait a minute, Miss.
I'm confused.
Hold on, Miss Powell. I'm looking at the case 2024 CV 00674.
Yes, ma'am.
All right. And plaintiffs haven't shown up.
No, ma'am. They were excused because defendant did not answer, and it was a motion that the court did not need to have a hearing on.
Okay. All right. So, sir, they filed a motion for contempt. There was no answer to the motion.
Excuse
and
me.
It says that.
Is this for me?
Yes. So.
Okay.
Yeah. So it says that they were seeking surrender of the vehicle. They filed a motion for contempt. You haven't surrendered the vehicle, but you didn't answer the motion.
How do I went to the courthouse once I got the letter, and I went downstairs to the state court on the left, the first door on the left.
That's
downstairs.
the right place.
And I talked to a black lady, and she told me that if I don't have the vehicle, she said that she'll like just tell you. And then I have to register the vehicle, and I think she said the only thing that I have to do is bring like the last like the registration or something, but I haven't had the vehicle in over a year and some change.
She shouldn't have told you much because she can't give legal advice.
No,
So
she didn't. No, she didn't tell me anything. She just told me that when I actually brought the letter, and
all
then
right,
she
so the court is
so
going to consider whatever's on the record and then make a decision at that time, okay?
how do you answer how do you answer that? I've
Sir,
never.
I can't tell you how to practice law.
How do you? I
And
thought I
the
was just
answer,
supposed to show up and
no, there's rules to this.
okay. So how do I proceed? Because I'm confused.
I can't tell you, sir, because I can't direct you how to practice law. That
Okay.
they filed a motion.
Right.
Generally, procedurally, if somebody files something and serves you with it, you have to respond. I can't tell you what the timing is. There's a time period in which to respond. There's a way to respond. All of those things that come with a lawsuit. But I can't, like when they filed their motion, you didn't respond. And so
Yeah.
the time to respond has passed. It's out, and your response would be out of time at this point. And when you went to the clerk's office, you didn't respond in any way that got into the court's record.
Yeah. So with me going down there, it wasn't basically well, no,
Yeah,
that
sir,
wasn't a
you
response.
actually have to put something in the record of the court. Talking to somebody at the clerk's office is
Yeah.
not sufficient.
So okay. So
We
now
can't, if you choose to proceed without an attorney, we can't tell you how to. I explain as much as I can procedurally, but I
yes, ma'am.
can't practice law for you. And
Right.
so if you proceed pro se, I can't tell you what you did right or wrong.
Oh, okay.
I can only tell you what I'm gonna do.
Okay. And what is the for me, because my dad has nothing to do with this. This my I'm a junior.
Okay.
He has nothing to like I haven't had the vehicle in forever. They came and picked it up. The only thing I got is like the little screenshots where I had like the Apple tags and they took them out the car, whoever like it was a black truck and they put it on a flatbed, but they took the Apple and I have the pictures of like it being on the highway in different places. But other than that, yeah,
I can't, sir, all
okay.
I can do is rule on what's before me. The motion
Okay.
to contempt is before me. There was no answer filed to that, and that's all I got. That's all I
Yeah,
can.
because on the paper, on the paper, it just says plaintiff filed motion to contempt, and it's on September 10th. But then it was like you called to be on a virtual November 12th at 1 p.m. And I've been in the actual thing the whole time. So,
Sir, when it says they filed on September, they filed the motion, you had a period of time to respond to the motion after they filed it.
yeah, but I didn't get the paper until October 8th, like last month.
Okay. I'm not sure what to tell you.
Okay, so I just need to get legal consultation, pretty much.
You can.
Okay. Okay, and then how do I come back and talk to you?
You have to file something.
Okay, so I just proceed how I tried to do it earlier, but I have to proceed to do it. I got you.
Yeah. I'm sorry, sir. My hands are tied.
Yeah,
Like I will try and give you as much of the procedure as possible, but I can't
yeah,
tell you what you need.
I ain't never been in trouble or gotten no stuff like that, so I'm kind of lost on this procedure.
I get you. I understand that. Unfortunately for me, my hands are tied because I can only give you so much information. Okay.
Okay.
All right.
Okay, so what do I?
Well, you will get my order in the mail, and then you can proceed from that point.
Okay. How long does it take for the order to normally come?
I'm not sure. This shouldn't take very long.
Okay. Okay, I got you.
All
And
right.
then, all right. Anything else you need from me?
No, sir.
Okay.
All right, the next case is Clayton County Board of Commissioners versus Cody Lamar Lee. That case was dismissed. Number 5, that case is VFS US LLC versus David Cornegay and Cornegay Trucking LLC. That is 2024 CV 06668. Anybody here on behalf of VFS US LLC?
Yes, Your Honor. Bo Hayes here for the plaintiff, Volvo Financial VFS.
Okay. All right. Anyone on behalf of Mr. Cornegay? All right. So, Mr. Hayes, this is case 2024 CV 06668. You may proceed, sir.
Yes, Your Honor. This is our motion for default judgment. The defendants were served. Mr. Cornegay was served personally as well as registered agent for Cornegay Trucking on the 12th of December last year. No answer has ever been filed. We filed our motion for default judgment in this case on the 8th of October, which included, I'm sorry, that was when the court issued its rule 9. Our motion for default judgment was filed on the 10th of September, in which we also included our client's business records affidavit pursuant to Rule 9.1 to establish the damages on the financing in this case. As that affidavit testified, Cornegay Trucking executed a credit contract for a 2018 Freightliner truck. Mr. Cornegay signed a personal guarantee for that as well. When they defaulted under the payment, the truck was repossessed. Notice of the sale was provided as required by law. Truck was sold in commercially reasonable manner, and as referenced in the business records, this is Exhibit C of my client's documentation.
Okay.
The balance was at the time of the default, the balance was $78,796.08. When they applied the $8,500 they got for the sale, but then deducted $440 for costs of reconditioning and having that sale, the balance is $66,736.08. The contract provides for the post-judgment default interest at the rate of 18%. The contract also provides for reasonable attorney's fees, which under Georgia law invokes Section 13-1-11, 15% of the first $500, 10% of the balance. And therefore, what we've asked the court for is that principal balance of $66,736.08, together with prejudgment interest in the amount of $21,425.02, which was calculated from the date of the sale of the truck, as evidenced on the sale notice that was attached to the affidavit. And then attorney's fees under 13-111 would be on that principal and interest balance, which is another $8,841.11. And we have calculated that we have costs in your court in the amount of $473 for filing, the electronic filing fees and service. Those are the sums we'd be asking for. We have previously uploaded to the court, I believe Ms. Powell should have our proposed order granting default in that amount.
Okay. All right, so the court finds that the defendant is in default for defendants are in default for having failed to answer the initial complaint. In this case, after sale of the vehicle, the amount sought by the plaintiffs is $66,736.08. plus prejudgment interest in the amount of $21,425.02, plus attorney's fees in the amount of $8,841.11, plus court costs in the amount of $473. Those amounts will be granted in judgment against the defendants.
Thank you, Your Honor.
All right, Mr. Hayes, thank you for your patience. All right, you're free to go at this time.
Thank you, Your Honor. Have a great day.
You too. All right, the next case is Dante Jackson versus Jarvis Johnson. Jonte Jackson versus Jarvis Johnson. Last call for Jonte Jackson versus Jarvis Johnson. It's a petition for review. This will be, yes. This will be dismissed for warrant of prosecution. The next
That's
case.
the actual motion. The actual motion is a motion for attorney withdrawal, so the petition should still stand, I think.
Oh, okay. I put that on these calendars so that I can make sure that the person understands what responsibility is theirs once the attorney withdraws. But if all of the requirements have been met for notice from the attorney withdrawal, the court is going to go ahead and sign that. Thanks, Ms. Powell. All right, on the next case is Riverdale MHP versus Mortimer and all others. Ms. Barksdale?
Good afternoon, Your Honor. I'm ready for Riverdale. This is an appeal from the magistrate court filed by the defendant, well, by Ms. Mortimer. This is a dispossession for past due rent.
All
And
right,
we're ready.
Ms.
We're ready.
Mortimer? Ms. Mortimer? Okay, Ms. Powell, is there a first name I'm looking for?
Kadisha?
Kadisha Mortimer? The courtroom has gotten off. Is there nobody in the courtroom? Is that why Castro signed off?
Yes, ma'am. At 1:30, there was no one in the courtroom, and I told her she can shut it down.
All right, thank you. All right, so Khadijah Mortimer and all others?
And we have a motion.
Yes, ma'am.
We'd ask the court to strike that answer and grant us a default judgment for past due rent from March 1st, 2025 at the monthly rate of $1,200 per month, $50 per month for late fees, trash, water, and sewage. And through November the 12th, Your Honor, the grand total of the past due rent and cost is $6,736 through November the 12th. And that is past due rent from March through November 12th. And that is $6,736 prorated.
All right, and that includes all of the late fees, all of those?
And I can submit an order on that, Judge, if you want to.
Okay, so the court is going to find that Ms. Khadijah Mortimer is in default, has not appeared today, has been given notice. In fact, this case was noticed several times, just to make sure that both parties were given notice and the ability to appear. Ms. Mortimer has appeared previously. She did not appear on today's calendar. The case is in default and her answer will be stricken. The principal amount of $6,736 in past due rent will be granted, plus court costs and late fees.
Thank you, Judge.
All right, thank you.
I'll submit an order later today.
All right, thank you so much. Thanks for your patience. I know we had some issues getting this scheduled and on the calendar.
Thank you so much for working with me, Judge. May I be excused?
Yes, ma'am. Take care.
Thank you.
All right. All right, and the next case is Avianta Contrell versus Progress Residential. Mr. Totten and Ms. Contrell are present, I believe.
Good afternoon, Your Honor.
All right, good afternoon, Ms. Contrell.
Good afternoon.
This is case 2025 CV 06497. And this is a petition for review. So the case was heard, I believe, in magistrate court. Is that correct, Mr. Totten?
Yes, Your Honor, there was a default judgment that was entered in magistrate court. And we separately filed a motion to dismiss the petition for review to do the court's lacking jurisdiction.
Okay. All right. And Ms. Powell, you reviewed the petition?
Yes, ma'am, I did review the petition and I also did review, I don't have the statute in front of me, but the statute that does confirm that the appeal was out of time.
Okay. All All right. So, Ms. Cottrell, the appeal wasn't made timely.
What does that mean?
Meaning that from the date of the judgment, you have a certain amount of time to appeal the case. And from what I understand, the appeal was not timely filed in the magistrate court for review by this court, or it was not filed in the state court for review by this court. Mr. Totten, you had a motion to dismiss. What was that based on?
Yes, Your Honor, it was based on two independent bases lacking jurisdiction. One, under OCGA 44-756, the appeal being filed beyond the 7 days. The default judgment was entered July 14th, and this petition was filed, it was in August. So it was well beyond the 7-day provision. Separately, Your Honor, independent basis why this court lacks jurisdiction. Court's not authorized to open or set aside a default judgment entered a dispossessory proceeding under Johnson versus Housing Authority. So either one of those, this court would not have jurisdiction to consider the petition for review.
So, Ms. Contrell, two reasons, and I'm going to explain them to you in plain language. Below, the magistrate court issued a default, meaning that you didn't properly answer the case when it first came up. Dispossessory cases, eviction cases are the rule of 777. So they have, when they filed their case, they got 7 days to serve you. You got 7 days to answer. If the court hears your case, then the court, and you respond and the court hears your case, the court can only give you 7 days to be removed from the premises. Like, I can't give you more than 7 days if a writ of possession has been granted. They can negotiate with you and give you more time to get out, but I can only give you 7 days. And if you are going to appeal it, you have to do it within 7 days of the court's judgment in the magistrate court. So everything is 7 days. It moves fast for evictions. You waited a month or so. And
I didn't even know that I had a court date, July 14th. I didn't know that I had a court date until I was in contact with my leasing people, and they had told me that a writ had been filed. And when I looked that up and found out what that was in August though. So I looked it up and I found out what it was, and I immediately tried to go to Clayton County, and it was closed for cleaning that day. So I literally went that Monday, and they were coming that Monday to come like put me out. But I didn't know that I had a court case on the 14th. Otherwise, I would have been at the court date.
Okay. Yeah, in the lower court, you would have been served either personally or by tack and mail. So, Miss Powell, can you see how she was served?
Checking right now.
But the bottom line is, you have to attack that at the magistrate court level. Like, if you didn't receive service and something was wrong with the service, then you would have to file that objection with the magistrate court, because I lose jurisdiction if you file an appeal that's beyond the 7 days past the magistrate court's judgment. I don't even have the jurisdiction to hear it. Okay.
Judge, I do see that service was made, but my system's just taking a minute to load to be able to tell you how.
Yeah. So I can tell you how service was made in the magistrate court, but other than that, there's nothing I can do in this case. The appeal would have to be dismissed.
And okay, so if I didn't get the paperwork and it was past the 30 days with magistrate court, could I still go back to magistrate court and try to like talk to them to do a payment plan?
This is what I say. Service is always an issue. So if you believed you weren't served, that's something you need to take up with magistrate court. But if they have proof of service, meaning the people who were supposed to serve you come back and they file with the court, hey, we served this person on this date by the statutory way of serving that person, then you would have to come with more than just your word of, yeah, I wasn't served. You're going to have to show something.
Yeah, I understand.
You got me?
I understand.
All right.
But I know they wouldn't have been able to serve me on the 14th because I wasn't even in town. So I know I didn't.
Well, now there's two different types of service. They can hand it to you, which is called personal service, but on evictions, they can do what's called tack and mail, where they put the information on your door,
Right.
and they mail it to you. So
It does say it was placed on the door, Judge.
yeah, it was tack and mail. So they have to put it on your door, and then they have to mail it to you contemporaneously, which means pretty much the same day. They'll put it in the mail. So that's up to you. But what I can tell you is I cannot hear this appeal. It's going to have to be dismissed.
And I can't go back to magistrate court?
I didn't say what you could or could not do in magistrate court. I'm saying that if you were to challenge service, it would not be here. It would have to be in magistrate court.
Okay.
But let me just tell you this, Ms. Contrell. If you're not paying your rent and you're in the apartment, then the Georgia law is very specific about that. If you're in a location and you're not paying for it, but you're still there, the landlord is entitled to the rent. If you have complaints about the apartment, you can complain and then they can fix it, or you can fix it and maybe have an offset to the amount of the rent. So if you have somebody come in and fix it, or if you fix it yourself and you spend money to do it, but you can't just stay in somebody's apartment or house and not pay.
Yes, I've been trying to pay them. I have been trying to
Well,
pay
here's
them
the other thing. If they file an eviction for non-payment, they cannot take payments.
Yeah,
They're
I'm
not
understanding
required.
this now that I've been going through the situation. I'm finding out now how it works because I've never
And
been
they're
in
not required to take partial payments. If you, even before they file an eviction, if you say, I want to make a partial payment, they're not required to take that. You agreed to pay the full amount. That's what your contract with them says. They agreed to give you a place to stay in exchange for the full amount. If you don't pay the full amount, they're not required to work with you. But if you don't pay, they're required, they need to get their place back. You're costing them money.
Mm-hmm.
Okay? So the judgment from the lower court stands, and if there's a writ of possession that's been issued, that will stand.
But you can't tell me if I can go back to magistrate court and
Ma'am, I can't. I can't practice law for you. What I can tell you is that I can't hear this case.
Okay.
And I can tell you that the way the Georgia law is set up, if you have not paid your rent and you have rent that is due and owing, they're not required to take a partial payment. They're not required to work with you. If you breach the contract by not paying your rent, then they have every right to go and get possession of the property.
Okay.
All right. All right. Is there anything else in this case, Mr. Totten, Ms. Cottrell?
No, Your Honor. I submitted a proposed final order with my motion. I'm not sure if Ms. Powell has that or not.
Yeah, she probably does. Ms. Powell, you have that, right?
Yes, ma'am.
All right. Yes, ma'am. Ms. Cottrell, you'll get a copy of it, okay? But Ms. Cottrell, nothing in life is free. If you're living in somebody's house and you agreed to pay them rent, you got to pay it.
Mm-hmm. I understand.
Because if you did, imagine that if you did work and people didn't want to pay you for working.
I know I'll be upset. That I know, I completely understand. That's why I was coming today. I'm trying to pay them. I thought I could.
Yeah, once they decide, let me just tell you, once they decide on an eviction, they want you gone. They don't want the money.
I've been in contact though with my leasing company, and they seem to be like they would be okay with me paying them the way that they talk. That if I pay them, the eviction would be dismissed from
Well, then
my.
they got to do something. They got to file something that says that they're going to cancel the writ of possession.
Okay.
Because I promise you, you can pay them. If they take the payment, that should cancel the writ of possession. But if we don't know, it will still go forward.
Okay.
So that's on you. All right. All righty. Ms. Powell, is there anything else on the 1 p.m. calendar?
Nothing else on the calendar, Judge. If you have like 2 seconds to hang back, that'd be great, but official business is done.
All right, thank you. All right, you all are excused. Ms. Barksdale, you had something?
Yeah, I did, Judge. I don't know if I remember saying to you that I wanted a written stand on that case with a judgment of 6736. So we need a written stand on that case.
You're entitled.
All right,
So
I sent you an order.
yeah,
Thank
put
you.
it in there.
Okay.
All right, thank you. All right, 1 second, Ms. Powell.
Thank you.
All right, Ms. Cottrell, you're free to go at this time, ma'am. Keep trying to, 1 second. One second, Ms. Powell. I'm trying to end the live stream, but I can't. It's not clicking. 1 second.
Thanks, Judge.
Hold on, hold on.
Oh.
Why is it not doing this? It's not allowing me to end the live stream. Hold on. Just keeps putting up a thing that says remind people to watch the live stream if I'm.
You want to leave and come back in?